Good morning, everyone. We are on the record in case number 2025-00175, electronic application of Kentucky Power Company for approval of a certificate of public convenience and necessity to make capital investments necessary to continue taking capacity and energy from the Mitchell Generating Station and other requested relief. I am Angie Hatton. I'm chair of the Kentucky Public Service Commission. Joining me today are Commissioner Mary Pat Regan and Commissioner Andrew Wood. If you have a cell phone, please set that to silent or turn it off at this time. The hearing today is for the purpose of taking evidence in this matter. And before we go further, I'll have entry of appearance of counsel and request that each party's counsel also identify their witnesses for the applicant.
Good morning, Your Honor. Katie Glass, Ken Gish, and Juan Dawson of Stites and Harbison for Kentucky Power Company. Kentucky Power's witnesses today are Tanner Wolfram, Lara Kahn, Joshua Snodgrass, and Alex Vaughn.
In that order?
Yes.
Okay. And for Attorney General's office?
Mike West for the Attorney General's office, and Lane Collin is our witness, and he's testifying for KIUC as well. He is available virtually.
Okay, I see that we got his link sorted this morning and got him online. And for Kentucky Industrial Utility customers.
Morning, Your Honors. Mike Kurtz, Jody Kyler-Cohen for KIUC.
Good morning to both of you. And you don't have a witness?
Oh, we are sharing Mr. Collin with the Attorney General's office.
All right. And for Sierra Club?
Christina Keith for the Sierra Club.
And I'm Nathaniel Schoaf, Your Honor, and with us today is our witness, Debbie Glick.
Okay. Good morning to all of you. I've been advised that public notice has been given and filed in the record. Is that correct, Councilman?
Yes, ma'am.
And I think there are a couple of outstanding motions. There's some for confidentiality that will get ruled on ASAP. And then there was a motion for deviation from notice requirements from the applicant. I did not see any objection to that. In that case, it'll be sustained. And
Thank you.
We'll get an order out on that as well. All right.
Your Honor, we also do have an outstanding motion to approve our settlement agreement, which was filed last Thursday.
I think we're going to hear some testimony
Yes.
today. Because not everybody signed on. Okay. Is there anyone present here today who came here for the purpose of giving public comment? I don't see anyone coming forward, so I will note for the record that comments may always be submitted on PSC's website at psc.ky.gov, and you may email us, make sure and include the case number. If you want to give a public comment, you can do so up until the close of evidence in this case, and include case number 2025-00175. All right, anything further before we commence swearing in witness? All right, applicant, call your first witness.
Thank you. The company calls Tanner Wolfram.
You know what? Pause, Mr. Wolfram, just for a second. I didn't do the stipulation. It's not actually in the script, but I think we should do that before we... Okay. So, Mr. Wolfram, stand down for just a second. I need to do this, and you can have a seat there if that's where you're comfortable. It's fine, but I need to do the stipulation script.
Yes, sir.
Before we start calling witnesses. So I understand that a settlement agreement has been reached between Kentucky Power and Kentucky Industrial Utilities customers, and that the Attorney General has signed as not opposing. Sierra Club has not joined that settlement. The settlement and supporting testimony was filed into the record November 13th, 2025. Is that correct, Ms. Glass?
Yes.
Could all the attorneys who participated, or anyone who participated on behalf of an entity in those negotiations and meetings and have signed on to the proposed settlement agreement, please stand and raise your right hand. All right. Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
Yes.
Yes, ma'am.
You can lower your hand. In order to ensure that the responses are accurately recorded into the record, we will, I don't think we'll go one at a time. I think we'll do it all at once. But if you're going to say no to anything, do so loudly and wave your hand, get back in. All right. For all of you, were you aware of and did you have an opportunity to participate in all of the negotiations that resulted in the settlement agreement?
Yes.
Yes.
Did you review the settlement agreement in its entirety, including exhibits and updated tariff sheets?
Yes.
Did you voluntarily sign the settlement agreement, and do you fully support each and every provision contained therein, or in the case of the Attorney General, not oppose?
Yes.
Are there any provisions in the settlement agreement that you do not understand, object to, or take issue with?
No.
Was any consideration of any kind offered, or were you any promises made other than what is expressly set forth in the settlement agreement to induce you to negotiate and sign the settlement agreement?
No.
Are you aware of any reason why the Commission should not adopt and approve the settlement agreement in its entirety?
No.
All right, please have a seat. And now, Mr. Moore, would you raise your right hand? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
Yes, Your Honor.
Okay. Tell us your full name and business address, please.
My name is Tanner Wolfram. My business address is 1645 Winchester Avenue, Ashland, Kentucky, 41101.
Counsel.
Thank you. Mr. Wolfram, can you please tell us the name of your employer and your position?
Yes, my employer is Kentucky Power Company. I am the Director of Regulatory Services.
Thank you. And did you cause to be filed into the record of this case direct testimony, responses to data request, and testimony in support of the settlement agreement?
I did.
Okay. I would like to ask you a few questions about your testimony in support of the settlement agreement.
Sure.
As the chair said, it's correct that the settlement agreement was entered into between the parties on November 12th and filed into the record on November 13th. Is that your understanding?
That's correct.
Okay. And as you said, you filed testimony in support of that settlement agreement, correct?
I did.
Who are the parties to the agreement?
The parties to the agreement are Kentucky Power Company and KIUC as the signatory parties, and the Attorney General signed as a non-opposition party to that settlement agreement.
Okay. And if I could have you turn to paragraph 11 of the recitals of the settlement agreement itself, could you give me a summary of what's contained in that paragraph, please?
Yes, absolutely. So the settling party, or the signatory parties agree that it is the least cost reasonable alternative to allow the company to continue to take energy and capacity from the Mitchell plant beyond 2028, specifically for the 2028 through 2021 or 2031 period, and support the overall approval of the CPC and application the company filed in this proceeding.
Okay, great. And can you tell me the major terms of the settlement agreement between the parties?
Yes, compared to the company's as-filed position, there are two modifications to the company's as-filed position, one being that the company has agreed to recover the $20.1 million associated with the ELG capital cost that it would be responsible for through 2040 instead of 2031 as proposed by the company. The parties also agreed to prospectively change the depreciation rates for the CCR investments that were approved in case number 2021-00004. Those investments were being depreciated through 2028. Consistent with that order, the parties have agreed to extend that depreciation through 2040. Both those investments will have special depreciation rates to ensure their depreciation through 2040. And at a higher level, the parties agreed that the CPCN allowing the company to take energy and capacity from Mitchell beyond 2028 should be approved.
Okay, thank you. And are those two modifications to Kentucky Power's application that you described generally consistent with the testimony filed by Mr. Collin on behalf of AG and KIUC?
Yes, they are generally consistent. The only slight modifications to Mr. Collins' testimony is that, one, we are updating the depreciation rates prospectively as opposed to recalculating the depreciation rates back to when the investments were made. And then Mr. Collin also mentioned ELG study costs that should have been, he recommended they would be recovered through 2040, but the company had already fully recovered those ELG study costs at this point, so that adjustment was not necessary.
Okay, thank you. And has the company had the opportunity to examine the bill impacts of the proposed settlement on the average residential customer?
Yes. Specifically on page S6 of my settlement testimony, as submitted in the company's as-filed position, the total bill impact for the environmental surcharge would have been $3.68, or a 2.02% increase on residential bills. The settlement position results in a $2.33 increase, or 1.28% to the average residential customer bill.
Okay, and how does that compare to the company's as-filed position?
Yeah, so the company's as filed position was $3.68 and 2.02% on a residential bill, as compared to the $2.33 or 1.28%.
Thank you. Are there any other notable provisions in the settlement agreement?
Yes, so the parties have agreed to continue to work and engage in good faith best efforts to seek securitization legislation associated with the remaining net book value of the Mitchell plant. The parties will agree to continue to make efforts with the legislature to get new securitization legislation passed, hopefully in the near term, so that we can securitize the remaining net book value of the plant to the customer's benefit.
Thank you. And are the terms of this settlement agreement contingent upon the legislature ultimately passing securitization legislation?
They are not.
Is it your testimony or your opinion today that the settlement agreement is reasonable and in the best interest of the company and its customers?
Yes, the settlement agreement balances customer interests by allowing the company to continue to have access to baseload generation, specifically from the Mitchell plant, which provides about 600 megawatts of accredited capacity to the company and its customers. And ultimately, the settlement results in a lower overall bill impact to residential customers as compared to the company's as-filed position. So overall, I believe the settlement agreement balances the interest of both the company and its customers.
Okay, thank you. So if I were to ask you the same questions that were contained in your responses to data requests, your direct testimony, and your settlement testimony today, would your responses be the same?
They would.
Your Honor, the witness is available for cross-examination.
Okay, Mr. West?
No questions.
Mr. Kurtz?
No questions, Your Honor.
Okay. And who will do first, Sierra Club?
No questions, Your Honor.
No questions. Okay. Staff?
Yes. Mr. Wolfram, could you look at page 8, lines 11 through 13 of your direct testimony? It just says there, the Mitchell plant's required to comply with the ELG rule in order for it to operate as a coal plant past December 31st of 2028. Is the ELG rule that you're referring to, it's the 2020 Effluent Limitations Guidelines Standards, is that correct?
That's correct.
Okay. However, there's since been a 2024, ELG standard proposed by the EPA, is that correct?
Yes, there's a ZLD related requirement, so that's zero liquid discharge requirement that is currently promulgated by the EPA.
And what is the compliance timeline for that standard?
Sure, so if you turn to Exhibit TSW3 of my direct testimony, it lays out kind of the path forward for the current environmental requirements associated with existing coal facilities. So if you look at the top line, the ELG compliance, which would be the ZLD related items, there are dates by which, to the extent you invest in the ZLD or not invest in the ZLD, it provides various retirement dates for that unit. So in the first example, if the company were to move forward with GHG requirements, which is obviously a separate rule, but not invest in ZLD, then the plant would be required to retire by January 1st, 2034. And as you move down, there's various GHG compliance options. If you move to the third one, the ZLD compliance with the 40% co-firing of Mitchell, that allows the plant to operate through January 1st, 2039, and the ZLD and 90% carbon capture investments, those would allow the plant to have no specific retirement date on the current EPA regs.
And you might not be the best witness for some of these questions, so if that's the case, please feel free to defer these to another witness. It's just, you kind of talked about some of the stuff, and so I wanted to ask you first, and, but if there's a need to defer, please feel free to do that. But, so I guess is the company's position, you have to comply with the 2024, the ZLD rule by 2029, or plan to retire by 2034. Is that accurate?
Witness Vaughn may be able to provide specifics. The one that I'm looking at specifically is the 100% gas co-firing option. I don't know if that, my understanding is that doesn't involve making ZLD investments for the entire operation of the plant, just the impoundments, but he can confirm that.
Do you know the difference between what was required by the 2020 ELG rule and what would be required by the 2024 or the ZLD ELG rule?
Not specifically in terms of like the technology that would be required, but I do believe Company Witness Vaughn or Company Witness Snodgrass may have some additional information on
So about the specifics of the technical aspects of compliance, it would be Company Witness Snodgrass would be the appropriate witness.
Yes, he can speak to the current ELG project that's in place at the Mitchell plant, yes.
Okay, thank you. On page 20, line 9 of your direct testimony, I'll just read it to you, and if it sounds incorrect, but you're welcome to go to it. Just under the current environmental regulations, the Mitchell plant can continue to operate as a coal plant through December 31st of 2031 without additional environmental upgrades. And then in Exhibit TSW3, the exhibit you were just referring to, it says install MATS compliance May 2027. But Exhibit TSW3 refers to West Virginia coal plants. Would the MATS compliance be necessary for Mitchell to continue operating beyond 2027, or does Mitchell not? Is there no compliance requirement for MATS related to Mitchell?
Yes, so there is mass compliance related to the Mitchell plant, but my understanding of that project, it is relatively small in scope.
Okay. So that would be necessary by 2027 in order to continue operating Mitchell?
That's correct.
Okay. Page 2021 of your direct testimony, line 5. I'll give you a second to get there. It says, on June 11th of 2025, the EPA announced a proposed rule that would repeal the 2024 GHG rules and the MATS rule. Specifically with respect to the GHG rules, does Kentucky Power have a position regarding whether the GHG rules are likely to be repealed?
I wish I could give you a yes or no on that. We have heard the current administration is evaluating those rules, either delaying the environmental compliance by a multitude of years or eliminating those requirements specifically, but we haven't seen anything specific in terms of what either the delayed rulemaking would be or whether or not those rules will be repealed. So we're obviously monitoring that. If the GHG and MATS rules are delayed, obviously the Mitchell plant can operate as is for a longer period of time without any additional upgrades for ZLD, which is one of the reasons that we're obviously making this application. We have the optionality in that scenario to have that plant available to us. To the extent that the current administration makes those EPA changes, then we have an existing baseload resource that we can continue to operate to the benefit of our customers without having to make those investments if the environmental regs are either delayed or repealed.
Is there an effort to repeal the ZLD rule also? It wasn't mentioned there specifically, but...
Yes, that's my understanding. I think it's kind of included in that overall GHG requirement, either a delay in that requirement or elimination of that requirement.
And you kind of alluded to this, but assuming that the 2024 GHG rules are repealed by the current administration, but a future administration seeks to reinstate the same or similar rules, would Kentucky Power's position be that that would nevertheless result in a delay of the implementation of the 2024 rule or something similar there too?
That would be my expectation. If the current administration either delays those environmental requirements, it would be hard to imagine being able to move those requirements back up to like the current due dates for those requirements, because obviously we've got decisions to make regarding environmental compliance or those options. So if they are delayed and we don't have to make those decisions, I think there would nevertheless be the delay in the timing on those re-implementations.
And now obviously that makes sense, but I don't know if Mr. Snodgrass would be able to provide, some color in that. In I guess if a rule's repealed, in the past and then re-implemented, kind of delays that have been seen, with respect to those rules. Would you have any, information on how that's occurred in the past and what kind of delays you've seen?
Not specifically. Again, my understanding is based on conversations with our internal environmental regulation experts, understanding how the EPA regulations are implemented, to the extent that you do see a delay in environmental compliance. There are challenges for re-implementing or going backwards, specifically in this instance, if these ZLD requirements were delayed, let's say 10 years, and a new administration comes in and says, okay, we want to revert back to the original date. Well, at that point, we're already past the due date for ZLD, so there will obviously have to be some give and take there from my understanding. But my understanding is that it's generally challenging to, move those posts backwards, generally once they've kind of been moved out.
And yeah, that's obviously logical. I just was curious if there was any information on how much delay you can kind of expect when that kind of thing happens. But I guess it's just, fact dependent.
It is, yes. We don't have obviously we don't have specific regulations in terms of what the EPA will ultimately propose, but we are absolutely monitoring that to the extent that we can take advantage of any of those opportunities, yes.
Are you aware of any, apart from the current administration seeking to repeal the current GHG rules, are you aware of any legal challenges to the current GHG rules with respect to the support for their implementation?
I'm not sure I'm specifically aware of any legal challenges. I do know there have been a couple facilities throughout the country that have sought relief from current EPA regulations. I believe there was a plant in Michigan, maybe a consumer's plant, that sought to be able to continue to operate past its retirement date, and I believe the administration had approved an exception for them to continue to operate that coal facility. So there does, given the overall increase that we've seen in electrification, specifically around growth of data centers and high energy users across the country, you are seeing I think multiple utilities reconsidering either retirement options or seeking the ability to continue to operate existing baseload generation.
Is Kentucky Power or AEP involved in any legal challenges currently against the 2024 GHG rules?
I'm not specifically aware of that.
And this might be for somebody else. I guess two questions. The convert Mitchell to 100% gas operation by 2030 is one of the long-term options. Are you aware of whether the 40% capacity factor limit on certain new natural gas plants that applies as a result of the 2024 GHG rule, does that apply to a coal plant converted to 100% gas?
I don't know that specifically, but Company Witness Vaughn may have that information.
And I guess along the same lines, you know what, I think you've already answered this. The ZLD, I'll ask Company Witness Vaughn or Snodgrass about the specifics of that. Looking at page 22, line 5 of your direct testimony.
I'm there.
It says on May 28, 2025, the Mitchell Operating Committee met and concluded that Kentucky Power would move forward with this application. Could you kind of explain, under what authority that meeting was convened and what the decision was at that meeting?
Sure. So there are naturally regular meetings of the Mitchell Operating Committee, specifically as it relates to, we have normal cadence to set budgets. We have meetings of the Mitchell Operating Committee when it relates to making certain investments in the plant or moving forward with specific projects. So before we filed this application, we had conversations with Wheeling just to let them know that this was something that we were evaluating. Once we made the decision that this was something that we wanted to pursue, we brought that before the Mitchell Operating Committee. inform Wheeling that this was the path that we wanted to move forward with, and Wheeling ultimately agreed that it was the right thing to do.
And what was the specific agreement at that meeting? Well, I won't put words in your mouth. What was the specific agreement at that meeting?
Generally, the company just informed Wheeling Power Company that it had planned to make an application to seek to extend its interest in the energy and capacity from the Mitchell plant beyond 2028. We informed them that that was the least cost reasonable alternative for our customers, and they supported our decision to move forward with the CPCN application.
Was approval from the operating committee necessary in order for Kentucky Power to, I guess, make the investment in Kentucky Power's, well, let me reset, actually. Kentucky Power, I know in the application takes the position that because the commission didn't approve the ELG project, and then there was a decision after that, with respect to the operating agreement, that Kentucky Power would have to divest its share of the Mitchell plant at the end of 2028. Is that correct?
My understanding is that the commission's order directs the company that it can no longer take energy and capacity from Mitchell beyond 2028. I do not understand the commission's order to require a divestiture of the company's 50% ownership in the plant after that date.
Okay. So Kentucky Power's position wouldn't be that, as a result of not making that investment, that Kentucky Power would have to divest its interest in the Mitchell plant?
As it relates specifically to those orders, I don't understand the orders to require that divestiture specifically. My interpretation from a layperson's understanding as a regulatory director is that those orders require the company or necessitate the company to no longer be entitled to energy and capacity from that plant in 2028. As such, if we are not entitled to energy and capacity from that plant in 2028, we will have to make significant purchases to cover the loss of accredited capacity from the Mitchell plant after 2028.
I guess what decisions does Kentucky Power contend are required from the Mitchell Operating Committee in order for Kentucky Power to continue to receive its 50%, or to continue to receive 50% of the capacity and energy from Mitchell plant? I guess my question is, you talk about the meeting and there's an agreement. Was that agreement required, and under what authority was that agreement required in order for Kentucky Power to retain its energy and capacity from the Mitchell plant?
Yeah, I apologize if I was unclear. I don't mean that there was a formal agreement of the Mitchell Operating Committee. The company had informed in Wheeling Power that it intended to make this application because it represented the least cost option to serve customers, and Wheeling was generally supportive of that application. Again, it's important for us to be in connection with Wheeling Power specifically, as they are entitled to that energy and capacity currently of the full 100% of Mitchell plant beyond 2028. So we wanted to ensure that it was still okay from their perspective that we move forward with this application. There wasn't, specific requirements or anything of the like that they were concerned with us making that application. So it was more informative, but they were ultimately supportive.
Is there, I'll get back to that actually. Are there any minutes for that meeting?
I believe so, yes.
I think we might request those as a post-hearing data request. Would that be an issue?
No.
I'm looking at page 22, line 11 of your testimony, your direct testimony.
I'm there.
starting with the sentence says, no changes in the Mitchell operating agreement itself. Or wait, I guess you were asked about changes to the Mitchell operating agreement. You said, no, changes to the Mitchell operating agreement itself would not be required. However, should the commission approve the application, the Mitchell Operating Committee would meet as soon as practical after approval to adopt new resolutions that terminate the ones adopted in the September 1st, 2022 written consent action that permitted asymmetrical capital investment in the plant. These new resolutions would reinstate Kentucky Power's obligation to pay equally for the capital improvements to the Mitchell plant pursuant to Section 3.2 of the Mitchell Plant Operating Agreement. I guess my question is, are you saying there were two agreements attached to your testimony? I think the original operating agreement and then the September 1st, 2022 written consent action agreement.
That's correct.
It might have been dated September 20th. But that written consent action agreement, are you saying there that September 1st, 2022 written consent action would be eliminated in its entirety if this was approved?
Generally, that's correct. The only provision that would remain is that Wheeling Power would continue to be the operator of the Mitchell plant.
Would have any other effects on the allocation of costs for the operation of Mitchell?
As I stated in my testimony, it would change the allocation back to a 50-50 share between Kentucky Power and Wheeling Power Company. Currently, as a result of the Commission's order in 2021-00004, capital investments at the Mitchell plant that have useful lives beyond 2028, Wheeling Power is allocated a higher share of those costs as the company doesn't have entitlement to energy and capacity from Mitchell in 2028. So as I discussed in my testimony, part of the application here is a result of getting Kentucky Power back onto 50-50 share of the investments that are currently in place at Mitchell. And then the cost allocation at that point would then be 50-50 moving forward.
And sorry, I should have been a little more clear when I said other effects. Like, would there be any other effects on the allocation of the costs other than the reallocation of those capital costs that you talked about? Like, would it change the allocation of O&M or the legal responsibility for O&M or fuel costs?
Not to my knowledge, no.
But it would have, the 2022 agreement changed, so Mitchell was operating, or Wheeling was operating Mitchell, and that would remain in place.
That's correct.
Are there any agreements other than the two that are attached to your direct testimony that govern the allocation of a responsibility for capital costs for the Mitchell plant?
Not that I'm aware of.
I'm not talking specifically about the capital costs at issue in this case, but more just generally how the contract would operate, assuming it went back to 50-50 allocation. On a going forward basis, like as capital projects come up, would Kentucky Power customers have to pay 50% of all capital costs for the Mitchell plant in order for Kentucky Power to retain its 50% share of the Mitchell plant?
Yes, that's what the Mitchell Operating Committee, or Mitchell Operating Agreement provides for. Again, that's part of the overall operation of the Mitchell Operating Committee, is to review budgets that would include, additional capital projects that would be required at the Mitchell plant. And so both the company, Kentucky Power in this instance, and Wheeling Power would meet, review those types of projects, and ultimately approve a budget to move forward. But that cost allocation would be reflected on a 50-50 allocation moving forward to the extent this application is approved.
And I understand that it talks about like a 50-50 allocation, but I guess in order to retain, where does that come from? And maybe I can ask this as a post-hearing data request. Where would that come from in the contract? That in order to maintain your 50% share that you would, I'm not even arguing with the premise. I'm just trying to understand the legal basis for it. in the contract.
Yes, there is a provision within the operating agreement itself that discusses how cost allocation, I want to be clear, there's no provisions related to change in ownership share that I'm aware of. It's just related to how the costs are allocated within the operating agreement itself. So there are provisions, I can look for them now if you would like, that discuss the allocation of project costs within the agreement itself.
I can do a post-hearing data request and ask just to direct us to those. And, I think I probably will ask, and, I'll let your counsel decide, to the extent to which you can answer either in post-hearing or in a brief. Just the basis for, and again, I'm not arguing, I'm just trying to understand, what the basis for the premise would be, but understand you would have the contract that would require the certain allocation, but then where do you get to that next step of, if there's a dispute or disagreement over cost, and ultimately Kentucky Power didn't pay a portion of the capital cost, where do you get, how do you reach the point where you believe that Kentucky Power would have to give up its 50% share?
Understood. Yeah, there are provisions within the operating agreement itself that provide for, the potential for some different allocation of project costs based on.
And I'll ask that as a post hearing, because I know that's not really something you could answer here. And, to the extent it's, it's definitely something that there's some interest in. And if, there's briefing on it or, in a post hearing, I think that would be helpful.
Sure.
And kind of along the same lines, I understand here the premise, with the ELG project, the premise was this needed to shut down, or it couldn't operate beyond 2028 if you didn't, complete the ELG project. But, for instance, if there's a situation, say with like the tower, I think there was one option which had potentially a 10-year life, and then another option, which had a longer life, which was more expensive. If, we were to approve this and it kind of goes back to the status quo, and then there's a disagreement between Wheeling and Kentucky Power or the West Virginia Commission and the Kentucky Commission, as to, what is the reasonable lease cost, option moving forward. If one chose, the cheaper option for 10 years and one chose the more expensive, would we be in that position again where someone would be, having to give up a portion of their capacity and energy?
Understood.
And what would the legal basis? And I can do that as a post-hearing. But, I guess with respect to the O&M for Mitchell, I know O&M is covered in there, and it talks about 50% or something effectively like 50% sharing. If the commission in the future, were to determine, with Wheeling continuing to operate, if the commission were to determine that, the cost of the O&M in a particular year were unreasonable. And I know Kentucky Power might take, there might be reasons where someone could take the position, well, that's not unreasonable, here's why we did it. But I'm just saying, assuming that the evidence indicated that it was unreasonable and that was the only real evidence, would there be a legal, could the commission make an adjustment of that O&M? Or would there be a contention that, there's a legal requirement to pay 50% no matter what, and that you couldn't make an adjustment for unreasonable O&M?
So my general understanding of the question there is, again, the company is currently being allocated 50% of the O&M related costs for Mitchell. those are annual expenses that the company has 50% interest in the energy and capacity for Mitchell right now, so it's responsible for 50% of those costs. We include those costs in various rate proceedings of which the commission can review the prudency of any of those investments. So, the commission can make that determination if the evidence is such. But I'm not sure I can go beyond that. Obviously, just stating the commission has the authority to review and approve or adjust any of our costs related to any of our proposed, recovery mechanisms.
I guess I was just wondering, like, if if you can't answer, then you can let me know, but, if Mitchell were dispatched, say, on an uneconomic basis, and the commission were determined that, doing so resulted in an unreasonable cost that the commission wanted to exclude as part of, either a general rate case or a fuel adjustment or some other filing, the company's position wouldn't be that there would be a legal prohibition on that.
I don't know that I can speak to a legal prohibition on that requirement. I can tell you that I believe there are provisions within the Mitchell operating agreement that provide for cost allocation, including instances where one of the members operates the unit differently. But that's the extent. I can't say for certain whether or not there's a legal prohibition on that or not.
With Wheeling Power kind of taking over the operation under the current agreement, does Kentucky Power's personnel still make decisions about when they want their portion to be dispatched? Or is that decision made by Wheeling Power?
Mr. Vaughn may be able to give you some more information, but my understanding at a high level is that unit is dispatched as a single, entity. It's not Kentucky Power or Wheeling Power making an individual decision. It's bid into the market by our ComOp commercial operations group based on market economics or a designated must run to the extent that requires. But Company Witness Vaughn could give you some further detail on that.
And if you need to defer this question to Mr. Vaughn or someone else, who makes the decision with Wheeling operating? Who makes the decision on how and when to bid the Mitchell plants into PJM?
Yeah, Mr. Vaughn can give you specifics on how that process is implemented.
Okay. I know part of the ELG costs that the company is seeking to recover in this case, I know it's about 78 million. It includes about 20 million or 20.1 million in kind of past amounts that were recovered from Wheeling Power, including carrying costs on Wheeling Power. Do you know, and I guess this kind of goes back to, what's in the agreement, but what would be, I would understand, I guess, having to cover their share of the capital costs, but what is the basis for, I guess, covering Wheeling Power's carrying costs since the ELG plant was constructed?
Yeah, so that provision is appropriate given the fact that West Virginia customers are currently paying and have paid for 100% of the ELG investment associated with making those investments. So if we go back to case 2021-0004, had the company been in the same position where the commission had approved both CCR ELG, the company would have been entitled to recovery of those capital investments as well as a return on and carrying costs associated with those capital investments. So this provision is required to get Kentucky Power back on level footing with Wheeling Power customers. Ultimately, the need for this is because the Wheeling Power and West Virginia customers have taken on that risk associated with making those investments, even though they were being allocated 100% of those costs. Now our customers ultimately, because of those investments made by Wheeling Power, our customers now have the optionality to continue to take energy and capacity from Mitchell beyond 2028 because of the investments made by Wheeling Power and paid for by West Virginia customers. So to the extent that our customers can now benefit from having that plant available to our customers beyond 2028, in my opinion, it is reasonable that we compensate Wheeling Power for what would have been our 50% share of the cost of the ELG equipment had we originally been approved that investment in the original case 2021-00004.
Just changing topics really quick for a second. Are you familiar with cases from the commission indicating that the commission is not able to grant a CPCN for projects that have been completed? But those cases also often indicate that the commission may authorize the recovery of those investments, they just wouldn't grant the CPCN.
I'm not specifically aware of that.
Okay. I guess, and perhaps, I can ask this as a post-hearing, or something that can be included in briefing, but, assuming the commission cannot grant a CPCN simply for procedural reasons, that the position is you can't grant a CPCN for a project that's already completed, but authorize the recovery of the amounts, would Kentucky Power contend that such an order would prevent Kentucky Power from retaining its share of Mitchell?
No,
Mr. Bellamy, are you indicating you will ask that as a post-hearing data request, or are you asking for a response from Mr. Wolfram?
If he can answer, if not, I can, do a post-hearing or both.
Okay, I think Mr. Wolfram can answer to the extent that it's not calling for a legal conclusion.
again, my general layperson understanding is if the commission were to approve the cost recovery associated with what would be the company's 50% investment required to have entitlement to the ELG equipment, then the company would move forward with making that payment to Wheeling Power and reflecting a 50% interest in the plant moving forward.
And I'll ask that as a post-hearing. It's just a point of order, really, but.
Okay, thank you.
Back on the carrying cost for Wheeling, were the carrying costs, how was the ELG investment reflected in Wheeling Power's rates? Was it immediately reflected, or was it reflected on some sort of delay?
I'm not sure I can give you that specifically. When we were building the revenue requirement, we worked with the Wheeling Power team. I don't fully understand all of their recovery mechanisms, but they provided us a revenue requirement for one of their recovery mechanisms that delineated their recovery of those ELG investments. I don't know the specific timing in terms of when that mechanism began recovering those costs, but I do believe that was included in one of our attachments. It may have provided a timeline showing how the cost was calculated ultimately to come up with that 20.1 roughly million.
Would to the extent that you recover the 20.1 million from Kentucky Power customers, would that full amount be credited to Wheeling Power customers, or would any portion of it be retained by AEP or Wheeling Power or Kentucky Power?
I don't know specifically the West Virginia requirements on that, so I can't speak specifically to what Wheeling would do in that instance.
I might ask a post-hearing data request about that. You had mentioned the securitization and kind of supporting new securitization legislation. And I guess you don't need to go into, too much detail, but would the legislation that you're thinking about, would that include the securitization of both regulatory assets and amounts associated with existing plant and service?
Yes.
And how would the securitization, just generally speaking, and you can reference, I know that West Virginia has something similar. How would the securitization of the costs associated with the plant and service function? Like, would Kentucky Power retain title or their 50% share and it would just be refinanced?
Yes.
You could kind of explain that just briefly.
Yeah, so the idea behind the securitization legislation that we're seeking is to securitize to continue to operate the Mitchell plant. So we would securitize the remaining net book value that would ultimately allow the company to reduce overall bill impacts associated with the operation of Mitchell to all of our customers. And then ultimately, with the securitization proceeds, we would seek to reinvest those securitization proceeds in additional generation within the Commonwealth. So our goal is to securitize to reduce bill impacts, reinvest capital in Eastern Kentucky, and ultimately continue to operate the Mitchell plant.
I don't have any other questions. Thank you very much for your time.
Thank you.
Commissioner?
Yeah, I'll ask a couple of questions. Good morning. Thank you
Good morning.
for coming this morning.
Of course.
I'm the new commissioner, so I think I can still get away with asking new commissioner-type questions. And I have not heard the terms CCR rule before or ELG rules, and I wondered if you might take a minute or two to explain sort of what you're looking at in terms of those rules.
Sure. So the CCR rule is the coal combustion residual rule. That rule dealt with certain ash, ash requirements, ash impoundments, and how we would ultimately have to monitor and remediate any of the ash related items for coal facilities. And Company Witness Snodgrass could probably speak a little bit better on the specifics of what the requirements were and the technology implemented to address the CCR. I think it's actually in his testimony. And then the ELG is the effluent limitation guidelines. So that again addresses similarly related environmental upgrades required to make the plant environmentally compliant. But Company Witness Snodgrass can provide some other information on specific, like what specific equipment was required to be installed and what it does specifically.
Well, that's exactly where I was going, so thank you for
course.
saying that. Are you, is your testimony that that the proposals being made today are the least bad option for Kentucky Power?
No, absolutely not. Our position is that, again, we looked at this on a spectrum of time, right? We, as a result of the 2021 order denying the ELG investment, the company began evaluating options to replace the energy and capacity from Mitchell. It engaged in an IRP analysis. As a result of the IRP, it engaged in RFP, so we went out to test the market to see what resources were available to get a sense of, what a replacement option for Mitchell would look like. Ultimately, as my testimony states, there were significant fluctuations in the market as a result of new EPA regulations and just a tightening of supply and demand for generation resources that caused, capacity prices to increase. So the company evaluated its RFP results specifically as it relates to thermal options to replace Mitchell. And based on its analysis, Mitchell continues to be the least cost option to serve customers. From our perspective, the Mitchell plant continues to provide safe and reliable service to customers, and it's the least cost option for customers. So I wouldn't classify it as least bad. I think it's the best option that we really have for customers at this point. And, overall, the bill impacts associated with making the investments are the least cost thing that we can do for our customers, and that's why we selected it.
What other options were considered besides just buying electricity off the market?
Sure. So the other options that we looked at as a result of our RFP, we were looking at various PPA options. As a result of the PPA RFP results, we did negotiate with one counterparty to secure an existing resource Those negotiations were ultimately terminated. And so at that point, we started to reevaluate the remaining PPA options that we had. But ultimately, when we were looking at the cost associated with the PPA options to replace Mitchell, Mitchell was ultimately cheaper, and that's what company witness Vaughn demonstrates in his direct testimony analysis, where we compare extending our interest in Mitchell versus replacing Mitchell with PPA options or buying through the market, and market continues to be the most expensive option. So we felt it prudent at that point to go ahead and make the filing to seek extension of our interest in the energy and capacity for Mitchell.
Is Kentucky Power a victim of the data center surge in electric demand, would you say, or?
Not to this point. The company does not have significant data center growth within its footprint specifically.
I guess what I'm saying is, would the PPA price have been cheaper probably before the surge in electric demand from data centers around the country?
I might have to defer to company witness Vaughn on that specifically, just because of the timing of the RFP. I would expect that to be part of the reason, but I think, especially with our thermal bids, the change in the EPA regulations, specifically the 111D rule, which required the additional ZLD investment, that also drove prices. So I don't know that I can say specifically it's absolutely the data centers. It's kind of a combination of all the factors.
Very well, thank you.
Thank you.
Good morning.
Good morning.
Can you walk through with us kind of the decision tree to enter into settlement discussions, where they start, and without getting into confidential
Sure.
issues, just kind of talk about the process and where on the decision tree is your jumping off point to enter into a settlement?
So generally speaking, when the company files its application, we go through the discovery process, and then typically, once we see intervener testimony and understand the position of the parties, that's when we'll start to engage to see if there are certain things that, we can all agree on to move forward with a settlement. So, typically speaking, we want to understand where the intervening parties are coming from, what their positions are, kind of things that they want to see as a result of the case, and then we take that back, see if there's anything that we're comfortable with in terms of something that we can agree to. And then ultimately, we work with the intervening parties to see if there's a settlement option moving forward. And in this case, I was very grateful that we had that opportunity, yes.
And not everyone signed on,
No.
correct?
No.
Are there still discussions going on to try to get them on board, or no?
Not at this point, no.
I'm sure you're aware that the increase in ratepayers' bills is a big concern. And I'm looking at your testimony, the original testimony, page 25, lines 3 through 10.
I'm there.
Can you talk through that a little bit? Normally, those price increases would go in effect right away, but you decided to hold back on that and carry those through 2031?
Yes, so the 20.1 million will ultimately represent an expense to the company. However, in this instance, instead of seeking immediate recovery of an expense like would be normal, right? Normal O&M, you recover that on an annual basis. We decided we wanted to avoid immediate rate impacts of our $20.1 million revenue requirement. So functionally, what we did was, okay, we understand we have a challenged socioeconomic status within our territory, so we try to evaluate options to reduce overall bill impact. So instead of seeking to run that 20.1 million through rates, the environmental surcharge immediately, we decided to extend that recovery, ultimately providing immediate bill impact relief for customers. And based on the settlement agreement, we've furthered that by extending the recovery even further. So customers are seeing, again, overall decreases from the company's as-filed position.
Is there anything that concerns you about the settlement that hasn't been discussed, or from an operational standpoint?
No, Your Honor. I think the settlement, as I stated on my direct, balances the interest. It allows the company to maintain energy and capacity from a significantly sized baseload generation resource. I think we all can appreciate the need to have that type of resource available to the company. Specifically, we're going to start planning for PJM planning years 28, 29 here in the near future, early next year. So we really need to understand whether or not we're going to have Mitchell as part of the system, because if we don't, our auction position will be challenged in terms of having to find short-term market capacity to replace Mitchell. So having a decision on this application, hopefully extending our interest in Mitchell, will be very significant from our perspective and ultimately our customers' perspective, because if not, they will be exposed to some of those market pressures that we talked about with the closing supply and demand on generation resources throughout the PJM region.
Okay, thank you.
Thank you very much.
Good morning, Mr. Wolford.
Good morning.
I wanted to ask you a few questions about that potential federal grant. Can you hear me okay?
Yes, ma'am.
Do you know what the timeline is or application process? Has that been?
Yes, Your Honor. So I'm aware that the DOE has recently changed that due date of the application to December 8th. So the company is planning to submit an application by that December 8th timeline. I don't have definitive dates on when we expect an award or any of the awards to be granted, but I do know the overall due date is December 8th.
Not a ton of information details have been disseminated publicly about that, but
Yeah, I have very limited information in terms of, what the timing and how the structure works. Generally speaking, I'm aware of the dollar amount that's available and kind of the three specific categories of grant applications that the DOE is currently taking. So we're currently working on our application and hope to submit it here in the next couple weeks.
yeah. Do you have an idea of how much you'll be asking for?
I do, but I think at this point, Your Honor, if you wanted that response, we may have to go into confidential session, just given some of the, I don't think anybody's application's in, so I'm happy to provide that, but
December 8th
yes.
will be in. So that'll be, at that point, can the public see that application?
My understanding is those will be public applications, yes.
And we won't have a decision yet in the case, so we could ask some DRs about that if we've seen it by December 8th. Assuming it were granted, assuming it were a considerable amount, how would that affect your ratepayers?
It would ultimately buy down the cost of any of the options to address the structural needs at the Mitchell Unit 2 cooling tower. So we're in the process of evaluating those options to make an application related to those, any options related to address the structural needs at Mitchell for the Unit 2 cooling tower. So ultimately, if the federal grant money were awarded, that would reduce the overall price of whatever project that we ultimately select as the right option for making those units safe and reliable.
It's a grant, not a loan, as I understand it. Potential grant at least. And so you would make some sort of a filing with the PSC if it were granted to let us know how you wanted to distribute that.
Yes, or it could be included in, depending on the timing, if the company files a CPC and application for the replacement option or the option to address the structural anomaly at the Mitchell Unit 2 cooling tower, it would be reflected in the company's cost of that option and the ultimate bill impacts associated.
And the perimeters around that loan, as I understand it, are designed to extend coal-fired power plants, or?
My general understanding is there's three different categories. One of those is related to, I believe, like retrofitting to either co-fire existing coal units or the like. The one that we're looking at is the rural component to allow for projects within rural communities that have existing coal facilities to address, potential needs at those existing coal units.
But the rural aspect of it would also need to include an aspect of coal.
Yes.
So it couldn't be used, I'm aware that we're to expect a CPC in from Kentucky Power sometime in 2026 for an additional generating unit. It couldn't be used for something like that.
Not that I'm specifically aware of it at this time, Your Honor.
Mr. Bellamy was asking you some questions about the federal environmental protection laws, and Those are the laws, the 2020 rules that require these ELG upgrades. You said that you didn't think it was likely that they'd be revoked? Did I understand that correctly?
No, I just have no basis at this point to know for certain if there's going to be a delay scenario in those environmental regs or if they are ultimately repealed. Like I stated in my testimony, we are aware that the EPA stated that they're evaluating those rules. I've been in some high-level discussions around, potential, thought process on how we would, operate to the extent that those rules are delayed. But right now, we're just kind of waiting on a signal from the EPA as to what they're ultimately going to do.
That's not in your control, and I understand that. It's not within the control of anyone in this room, but it might delay compliance rather than outright revoke the requirement for compliance,
That's my understanding, yes.
maybe.
Yes.
It
So
could
there's,
revoke, it could delay. At what point does that affect your expectations from your ratepayers or level or length of amortization period? I mean, like, how are you thinking about that, and how will your ratepayers know, and how will the PSC know if compliance gets delayed? How that affects a ratepayer's wallet?
Sure. So, right now, as we said, to the extent that the EPA rules aren't either delayed or repealed, the company will have to make decisions, assuming that it is the interest in energy and capacity from Mitchell is extended beyond 2028. We will have to make a decision on which environmental scenario that we ultimately comply with. If the EPA regulations are delayed and we can continue to operate the plant as is, that is obviously one of those options that we will continue to evaluate. Obviously, in that scenario, if you're kind of business as usual, you don't have to file CPCN applications necessarily, depending on what kind of projects are required to, just normal operation of the plant. But, I think we can evaluate ways to communicate that to customers to the extent that, that remains the option for the company's ultimate compliance option. So, right now, we're kind of in a position where we're waiting and seeing, but also evaluating, what compliance steps we would ultimately take to the extent that those regs remain on the books.
Yeah, and to further illustrate how hard it is to regulate utilities as well as run a utility in today's current atmosphere, what about the opposite scenario? What about in 3 years? Or potentially after midterm elections in 26? Like, what if the exact opposite happens? What if suddenly all of these requirements are back in place and the federal government is no longer intending to incentivize coal-fired power plants being continued? How are you thinking about that, and how could you reverse course? And I'm sorry, that it's a horrible question that I'm
No,
asking. But tell me how you're evaluating these things.
Yeah, so I think specifically as you looked at Company Witness Vaughn's testimony, that's part of the process that we're engaged in right now, where he's evaluating post-2031 options. And we're looking at it from, what's the overall cost of any of the compliance options? How does that impact our customers? Do any of the compliance options bias in terms of, time that the Mitchell plant can continue to operate either under a new paradigm or, 40% co-fire or 100% natural gas conversion. So I think his analysis is really kind of where we're at. We're evaluating those options to the extent we're planning right now as if those EPA regulations remain in place. And so we're evaluating those options. And then to the extent that we get to a place, the timing of these rules is ultimately going to dictate when we have to file. The EPA can't wait hopefully too much longer.
Right.
Because we need to understand what the paradigm is. Assuming they don't act and the rules remain in place, then we will have to make applications to select a compliance option, which would include, either making the ZLD investments, co-firing the unit, or converting to gas. So we are evaluating all those options right now, currently planning to the current regulations.
Yeah. So the first time this relief was requested was in a 2021 case. That was during the first version of the current administration, the first Trump term. but I think the decision didn't come in until 2022, if I'm remembering it correctly.
I believe the order came out in July of '21, and we were on rehearing through 2023.
In 21, okay.
Yes,
Okay,
yes.
so at that time, we were still in this administration. Sorry, first version of Trump administration.
I think that's right. I don't
Is
know.
that right?
That would have been the first year of the.
No, that was Obama.
First year of the Biden.
Okay, 16 through 20, and now 20. Okay, gotcha. But so it was found unreasonable under the current expectations to continue coal plant operations, or to continue these, but now everything's changed.
Yes, Your Honor, I think we talked about it a lot in this proceeding, but we are in an entirely different world in terms of utility planning, specifically generation planning, given, the increase in electrification, data centers, the constraints on generation markets right now. I think in my testimony, I talked about the PJM BRA pricing was clearing at, $27 a megawatt day, and now it's over $300 a megawatt day. So there has been significant cost shifts, and that's why we went through the total evaluation again, and ultimately, given those changes, Mitchell is a plant that we feel very strongly needs to continue to be part of our portfolio, because being subject to those market conditions that are out there right now would be very challenging, both for us and our customers.
So Commissioner Wood was asking you a little earlier about the effect of the data center rush and the giant load capacity expectations coming up in relation to that. That did at least affect market prices and how reasonable it is to think we could rely on the market.
Yes, it has an impact as well as, the currently existing EPA regulations have impacts on, generation prices generally, because obviously if you have to comply with additional environmental regulations, your costs to operate go up. So that's building into some of that price as well.
Under current law, federal law, this plant can't be operated beyond 2028 without these ELG upgrades.
Correct.
I think everyone agrees on that.
Yes.
Yeah. And if it's revoked, we don't know.
And so my understanding of what the EPA is looking at is not related to the current, I'll call it ELG-1, which is what has been installed at the plant. The ELG-2 and the greenhouse gas rules and the MATS rules are my understanding of what the EPA is looking at in terms of either delayed environmental compliance or potential revocation of those rules.
Gotcha. Okay. So since this ELG upgrade was denied in the 2021 case, what planning has Kentucky Power been doing to either acquire or build generation? It feels like this is a little late. It feels like this is going back and trying to do something that's hasn't, it feels a little bit knee-jerk at this point. What planning have you been trying to do to build, ask for authorization to build or acquire generation?
Sure. So as I kind of walk through a little bit, after the 2021 case where the ELG was denied, almost immediately we rolled into our IRP planning to identify, and as part of our IRP, that IRP selected options to replace Mitchell because our IRP planning reflected Mitchell no longer being part of our generation portfolio after 2028. So based on what the IRP preferred plan was, the company went out and solicited an RFP for replacement resources. As a result of the RFP, we engaged in negotiation with the Bright Mountain Solar Facility, which we brought the application to this commission in 2024. And then we were also engaged in discussions to buy an existing facility. At that point, we were evaluating that option. We got to a point where those negotiations were ultimately terminated, and then we had to make evaluations. So we've been very specific in terms of our planning. We have been evaluating replacement options. We went to the market to test it to see what was out there. And then after we tested the market, we looked back at Mitchell and said, this is still, from our perspective, the least cost option. We knew we had a little bit of lead time because our interest in Mitchell continued through 2028. So we were trying to evaluate, and we did evaluate whatever options we had to replace Mitchell. But based on all the analysis we did, Mitchell was the least cost option for our customers, and that's why we brought in the application when we did.
You want me to direct any questions about decisions about non-economic dispatch to Mr. Vaughn?
Mr. Vaughn would probably be the right witness for that.
Okay. I will ask you an overreaching question
Sure.
about a 50-50 ownership. Generally, an odd number is better for decision-making, just because what if they disagree? If
The-
we're 50-50 partners with our sister or brother power company under AEP's roof, who makes a call if you disagree? Or is there a plant manager that makes the decision?
So there, on the Mitchell Operating Committee, there are 3 voting members. So it would be Company President Wiseman for Kentucky Power, Aaron Walker, who is the president of Wheeling and Appalachian Power Company, and then there is an AEP SC representative that would function as a tiebreaker to the extent there is disagreement amongst the 2 operating company presidents.
So it sounds like parent company makes decisions.
No, I wouldn't say that. I think it's, again, we're
Unless the
evaluating.
two of you agree.
Yes, my experience with the Mitchell Operating Committee is that we are usually very aligned in terms of, doing the right thing for our customers and picking whatever options that we need to provide safe and reliable and least cost reasonable service to our customers. So I would say that we are generally in line. I think Wheeling Power and Appalachian Power have, similar challenges that we do, and so we are really trying to find ways to, improve, our reliability, our affordability. We're looking at those options, so I would say we're generally aligned, but we do have a tiebreaker to the extent necessary. But in my experience, that has not been necessary, at least in any of the operating committees I'm aware of.
As I understand it, some of the non-economic dispatch decisions were made because coal was on the ground and they couldn't store anymore and needed to burn some of it. Does that sound accurate? Or if it's something you don't know about that, I'll accept that answer.
Yeah, generally speaking, there are instances where the company evaluates, the cost of paying liquidated damages for not being able to take coal supply because the coal pile.
Long-term contract.
Yeah, exactly. So if the coal pile at the facility is full or too high and we can't take additional deliveries, then we will look at, burning off some of that coal, running those units as must run to buy down the pile so we can continue to take those deliveries, so we avoid potential increased costs on the back end of those contracts.
Is any of it Kentucky coal?
I don't know specifically. Mr. Snodgrass may be able to help you there.
All right. Which Mitchell unit is it that hasn't been terribly reliable? Is it Unit 1 or Unit 2?
I would note that the Mitchell Unit 1 E4 is a little bit higher than Unit 2 has been. So E4 is equivalent forced outage rate, so that unit has experienced more E4 on that. But I would note that, as company witness Snodgrass had pointed out in his testimony, there have been significant improvements in both units, E4 in recent years.
I understand that, and I can ask him some more questions about that, but is it one or both that is getting these upgrades?
The ELG upgrades, it would apply to both units.
So as I understand it, this is a 54-year-old coal plant,
That sounds about right, yes.
older than me.
And me.
My kids will tell you it's real old. It has about a 25% capacity factor,
I don't have that.
according to your,
I don't have that specific number off the top of my head, but
and I won't make you confirm that for me. If you don't know it, that's okay. I think that might be my understanding. It can be fixed on redirect or go with another witness. So the original application process was that, or proposal was that it would be amortized, the ELG cost, amortized over about 6 years. And
Yes, Your Honor.
under the settlement, that'll extend till 2031 through 2040?
Yes, Your Honor.
Okay. So that lessens the bill impact in the short term for your ratepayers?
That's correct.
Less shock in the bills.
Yes, Your Honor.
Would they in fact, though, pay more in the long run because of the carrying costs?
I'd have to look at
Drag it
the,
out that many years?
I'd have to look at the revenue requirement specifically. I think it remains relatively close, but there may be a higher overall bill impact from a totality perspective. But the reductions, it's important to remember that they're not only getting the customers are also getting the decrease associated with the CCR investments being pushed out. So there are multiple components that customers are receiving the immediate benefit for. And ultimately, that remains true in a world where we don't get securitization legislation. If we are able to secure securitization legislation by extending the recovery of these assets, that will allow us to securitize those assets, which would ultimately result in lower costs to customers as compared to either proposed scenario.
You mentioned the securitization costs. I understand that the settlement is not predicated on the fact that that has to happen, the securitization legislation has to pass. It's not a deal breaker as far as any of the parties were concerned, and that was made clear. But is it still cost effective to secure it? Like, is the securitization only cost effective if Mitchell continues to operate through 2040?
I just want to make sure I'm answering your question. Is your question whether or not we would seek securitization legislation if we had to identify a replacement option for Mitchell?
I think I'm trying to ask you the opposite of that.
Okay.
Is this all still a good idea? Is it still cost effective if securitization doesn't happen? I understand you still want to enter the settlement, so that makes me think that you do think it is, but
Yes, I think either scenario, with securitization or without securitization, Mitchell represents the least cost option to serve our customers. The company is acutely aware of the impacts to our customers and the challenges that occur within our service territory. So we are fighting as hard as we can to identify cost-saving options for our customers. Specifically as it relates to the company's future generation portfolio, we want to be able to make the necessary investments in additional generation while keeping bill impacts, generally the same if we can. And securitization would be an avenue that would allow us to keep those bill impacts associated with any new gen down as low as we can get it. So we are trying to identify ways to make immediate impact to our customers. Ultimately, either way, though, this is still the least cost option for our customers, extending our interest in Mitchell.
so the most recent securitization case is expected to save customers somewhere between $75 million and $90 million over the long term. Is that still accurate?
Is accurate as far as I know, Your Honor.
Decide how to ask this question. The proceeds from that securitization, a lot of it went to pay down debt.
Yes, Your Honor.
Some of it went back to your parent company, and there were equity decisions.
We have not paid any dividend to the parent company as a result of that securitization.
Not as a dividend, but wasn't it $83 million in equity?
So the company, in its currently pending rate case, has proposed to make an equity contribution to the parent associated.
You're right, that is in the current rate case.
Yes,
I'm
Your
going
Honor.
to skip those questions. We
Yes, Your
can deal with that later. But, and so in that case, I will also not ask you now to tell me what you do with the securitization, but might be able to understand how that would upset ratepayers, to think that we securitize it because it's supposed to save them money, but then it goes back to a parent company.
Sure, I'll be ready to explain that, Your Honor.
All right. And the settlement, as we discussed, does have smaller monthly increases
Yes.
because of stretching out the amortization, but it's not from reducing total costs.
Sorry, could you repeat the last part?
Not from reducing total costs, just from stretching it out.
Yes, that's generally correct.
And you weren't able to answer at this point if it would actually increase total cost, but we know it won't reduce total cost.
Yes, from a total cost perspective, generally, as you extend capital investment recovery and the company's entitled to recovery at its WACC, the total increase can be higher, but the immediate bill impacts, it's especially important now while we continue to advocate for securitization legislation, because we can ultimately, if we have those, larger rate-based balances on our books, we can securitize that larger amount to provide even more cost savings to customers. So that's part of the calculus when making the decision to extend recovery of those assets.
As far as the total cost of building the cooling tower, these might not be, you might not be the right witness for these, but do you know why it has gone from a total cost?
Your Honor, we might interrupt you, sorry, but I believe the information about the cost are confidential.
Oh, thank you. Thank you.
Didn't want to interrupt, but just wanted to be sure.
No, please interrupt me in those circumstances. Are you the best person to answer those questions? And if you are, we'll go into the closed session, and if you're not, then I'll save that closed session for the person who's best able to talk to me about those costs, why they may have gone up and.
The details on those costs, company witness Vaughn would be the correct witness on that.
I will save the confidential session then. And make myself a big note not to forget that. I'm jumping around a bit.
No, you're fine.
Sorry. Sierra Club's witness was of the opinion that gas conversion at this plant would have been least cost. What's your response to that?
As company witness Vaughn's analysis states, and actually I'm going to pause just to make sure that I don't remember if his analysis on that was confidential or not before I get into it.
I think depends on where you go. Sorry.
And if you need a minute, I'm willing to do a 2-minute
Yeah, I
break.
just think as long as we stay out of the
Yeah,
actual
I don't want to
specifics.
put confidential things on the public record, but I don't
Yeah.
want to go off public record if I don't have to.
Yeah, getting into the specific prices and costs would be confidential because they're potential future investments. The broader discussion about, company witness Vaughn's rebuttal to the Sierra Club witness Glick's testimony is not confidential.
So broadly, don't mention any numbers, but tell me.
Got it.
Yeah,
what-
that was the short answer of what I was trying to say.
So broadly speaking, company witness Vaughn's analysis as it relates to post-2020 or 2031 compliance options does show that is correct, but ultimately, and he can speak more to the analysis, but that is factoring in various alternatives, including, having to comply with the currently existing APA regulations. So again, that's part of our overall analysis on the future of the Mitchell plant beyond 2031. But at this point, without approval of this application, that decision will if the company is not entitled to energy and capacity and isn't responsible for the costs associated with those environmental upgrades or conversion, those decisions would largely be Wheeling Power's without approval of this application. So we want to be in a position to be able to be involved in that decision making.
That would be Wheeling Power's decision.
At that point, their customers would be, if this application were to be denied,
This application were denied.
yes, then they're entitled to 100% of the energy and capacity from the plant at that point. So, their decision-making on what the future of that plant would fairly be for them to make that decision.
Was the possibility of short-term PPAs from Wheeling discussed?
No, not specifically within the context of this, and Company Witness Vaughn can walk you through why that's ultimately not the right option for our customers.
I'll let you get a drink.
Thank you, Your Honor. Sorry. I know that's loud.
It's okay. Won't wait till you get a drink in your mouth and try to ask you questions. Okay, so part of the request here is for, I think it was $20.1 million to basically reimburse the West Virginia ratepayers for upgrades that their PSC authorized that Kentucky PSC did not. Is that number about right, 20.1?
Yes, Your Honor.
Do you know if the West Virginia customers get that money back? Or I know that's not your call, but you know.
I don't know specifically. I'm not as familiar with the West Virginia, the rules. The Kentucky rules keep me plenty busy on a day-to-day usually.
I feel like if we checked our YouTube views from West Virginia today on this hearing, we'd get some.
Pretty high, I would assume,
I
yes.
don't even know if you can check where people are watching from, but I imagine they're watching this with interest and probably hoping that they're going to get some of that money back.
Yes, Your Honor, I can't, we haven't had specific conversations, at least I haven't been engaged with specific conversations around that with Wheeling. At this point, my conversations with them have just largely been around identifying what costs their customers have ultimately paid, and then, what we would need to do to ultimately continue with our 50% interest in energy and capacity for Mitchell. So I've not been in specific conversations around how they would handle, any of that amount for their customers.
Well, unfortunately, Kentucky Power customers compete with Wheeling Power customers for who has the most poverty that you need to deal with, and we have to set rates, you have to charge rates to those folks. Right now, Wheeling Power charges, just from my internet search, so not confidential, found it on the internet, 17.5 cents per kilowatt hour. And then they have a current rate case where their Wheeling Power is requesting a 14.12% increase from an internet search again. Kentucky Power's current rates, as far as I can tell, are 15.33 cents a kilowatt hour, or thereabouts.
Sounds about right.
We just added a 6.37% surcharge for the securitization. That's in addition, that's not included in the 15.33 cents per kilowatt hour. This case, if the settlement is approved, the rates in the settlement would add another 1.28% to the bills. So, I think that's $2.33 a month.
That's correct, Your Honor.
Then there's also a rate case pending that asks for another 14.9% increase. I understand that I am probably oversimplifying this math, and you tell me if I am, how far off base I am. But if that 14.9% increase were granted, we would be somewhere for Kentucky Power customers at 17.61 cents per kilowatt hour. And I'm not going to make you do math in your head. Do you know if that's about right?
Not off the top of my head, I don't know.
In addition to the 6.37. I mean, at that point, we would be higher than Wheeling in rates. We're not right now. Where are we? Where's the bright spot? Where are your customers going to find a bright spot here? And after this rate increase that's coming up, request, there's also, we're told, a CPCN after that. I understand you need capacity. I don't think that's disputed at all. But where's the bright spot? show, tell me, tell your ratepayers.
Yeah, absolutely. So I think, again, we are obviously very aware of the challenges within our service territory. And I think if you look back, even back to our 2020 rate case, the company has oftentimes walked into those filings self-mitigating our asks, right, in terms of, what we decided not to ultimately pursue, costs that we think are reasonably incurred, but we're not seeking recovery of them, or we're delaying cost recovery of them. And so I'm challenged every day by company President Wiseman, and I challenge my team every day. What are things that we can do? What are things that we can do to lower rate impacts, think about things differently? I've really, in the last year and a half, I've really challenged our team to think creatively, to identify cost savings. The number one thing that we have right now is getting new securitization legislation so that we can positively impact bills and ultimately reduce the cost of new generation, right? Like, theoretically, the idea behind securitization, pairing it with a new generation, right? The securitization would ultimately shrink the company, and then you grow the company with the new generation, so you're about the same size. So customers get an additional capacity resource at, similar cost. So we're really focused on ways that we can ultimately provide positive bill impacts. I think you've seen it, and I don't know if I can talk too much about our rate case, but in our rate case proposal, we were very intentional in our ask. We didn't update depreciation rates for Mitchell, which would have been an additional $11 million on our revenue requirement, because we are fighting right now for our customers at the legislature to get new securitization legislation passed. So we're holding that type of expense out there. We are, the company is, we understand that customers feel, there's struggle associated with, these bill impacts, but the company is also in a position where it is experiencing those same challenges by, self-mitigating asks and ultimately trying to identify ways to reduce our overall bill impact. So to our customers, I would just tell you, we're doing everything we can to identify ways to save money and make positive impacts on your bills. We're obviously subject to various market conditions, but we are trying to do things intentionally and creatively to make positive impacts. So
in the meantime, what's the total amount in this case that's being requested?
for recovery, it would be the approximately 77 million associated with the capital catch-up and for the expenses already incurred, and then the 57-ish million that would transfer to Kentucky Power's books, which is the remaining rate base on ELG equipment. And then the company is also seeking prudency review of the 60.4 million associated with the asymmetrical pricing that was required as a result of the 2021-0004 case. Because of our interest terminating in 2028, capital plant has been allocated at a higher ratable share to Wheeling in those instances. So we would seek prudency review of that, but the company is not currently seeking recovery of those amounts.
So the total?
Total 138 million.
That was the number I had in my head, but I wasn't certain that I'd caught everything. So in the meantime, while Kentucky Power struggles to come up with a long-term bright spot for your customers, and I hope you see sympathy on my face. I don't even know if I should have, like, at this point I do have sympathy. I understand that these are very challenging questions for this company. In the meantime, while we look for a better solution to be able to tell them, we're going to spend potentially here $138 million more ratepayer dollars to invest in a 54-year-old coal plant that doesn't burn Kentucky coal or employ Kentucky people or pay Kentucky property tax. And that may well be the least cost option. But tell me how to say that differently. Tell me how I'm seeing that incorrectly.
Yes, so, Your Honor, I would just tell you that we went out and we tested the market to see if there was an option for us to ultimately replace the energy and capacity of Mitchell for cheaper than what the Mitchell plant can operate at, and there wasn't anything in the market to do so. So once we've made that decision, now we've got to find ways to provide overall positive bill impacts associated with that decision, and that's my task as Director of Regulatory Services, is to continue to find ways to make positive bill impacts for our customers, and I am committed to that. So I understand, I understand, I've seen some public comments on a similar vein, and I would tell you that, again, we are making we're asking to make the investments necessary to keep bills as low as we possibly can, and that is what the Mitchell plant allows us to do. Otherwise, we will be subject to, the conditions within the market, and it would be very challenging for us. I think we've evaluated and overturned every stone that we can in terms of generation options. I walk through all the steps that we've taken to try to figure out what we needed to do and what our generation portfolio would ultimately look like. And every time it just came back to Mitchell is the right thing to do for customers, and I'm comfortable up here supporting this application because I know it's the right thing to do for our customers.
And we're all going to go to Pikeville in a couple of days and
Yes,
get
ma'am.
to see some of those customers. I don't envy you your job, and I imagine you don't envy mine either.
That's correct.
We've all got tough decisions to make. All right. Anything further from commissioners?
I do, but I think, I have to ask it at the meeting.
Okay. All right. Redirect.
No, Your Honor.
So in that case, no recross. Will Mr. Wolfram be the witness that isn't excused? Is he your lead witness today?
He is our lead witness.
All right. So I am sorry, I'm not going to be able to excuse you. I can tell you that you're welcome to step down from the stand, though.
Thank you, Your Honor.
All right. And at this point, let's take a quick break.
Chair, can I note, Mr. Collin was having some difficulty with the audio for the teams, so I just want to note that if somebody can.
Did he say any specifics about?
He said the chair and the witness, he was having difficulty hearing, so.
Well, I didn't have my microphone covered Candace? All right, we are back on the record, and case number 2025-00175. And counsel, you may call your next witness.
Thank you, Your Honor. The company calls Lara Khan.
Ms. Cohen, would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury? Thank you. Please be seated. Tell us your full name and business address.
My name is Lara Michelle Kahn. My business address is 1645 Winchester Avenue, Ashland, Kentucky, 41101.
Mr. Gish?
Thank you, Your Honor. Ms. Khan, can you please state your employer and your job title?
My employer is Kentucky Power Company, and my job title is Manager of Regulatory Services.
Thank you. And did you cause to be filed in this case direct testimony and responses to data requests?
I did.
And if I were to ask you the same questions that are in your direct testimony and in the data request to which you responded, would you give the same answers?
I would.
Thank you. Madam Chairman, the witness is available for cross-examination.
Thanks. Mr. West?
No questions.
Mr. Kurtz?
No questions, Your Honor.
All right. Sierra Club?
No questions, Your Honor.
We did not have any questions for this witness.
Didn't have questions? Okay. Mr. Wood?
I don't have any questions here.
Commissioner Reagan? Well, I should have come up with some questions. I thought I was going to have quite a while. All right, you must have given very good testimony.
Thank you.
And any reason this witness can't be excused?
No, Your Honor.
I don't think we're going to be here till midnight. Okay. Name your excuse. Thank you.
Thank you.
All right, call your next witness.
Okay, thank you. The company calls Joshua Snodgrass.
Good morning, Mr. Snodgrass. Would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
Yes, ma'am.
Please be seated and tell us your full name and business address.
All right. My name is Josh Snodgrass. I work at the Mitchell plant. It's at 899 Energy Road, Moundsville, West Virginia, 26041.
Gotcha. Counsel?
Thank you. Mr. Snodgrass, can you please state the name of your employer and your position?
Yes, ma'am. It is Willing Power, and my position is the Mitchell plant manager.
Okay, thank you. And did you cause to be filed into the record of this case responses to data requests and direct testimony?
I did.
Do you have any changes or corrections to any of that information?
I do not.
If I were to ask you those same questions today, would your answers be the same?
Yes, ma'am.
The witness is available for cross-examination.
Mr. West?
No questions.
Mr. Kurtz?
Just a couple. The Mitchell units 1 and 2 were both built in 1971?
Yes, sir.
Okay. Do you know that, KU's Gent Unit 1 was built in 1973, commercial operation?
I'm sorry?
Do you know if KU's Gent Unit number 1 went into commercial operation in 1973?
I'm not certain.
Is it your understanding that around the country, let me ask AEP, is AEP extending the life of any of its regulated coal plants besides Mitchell?
We have in the past. I mean, Big Sandy's a great example. I used to work over there, and we took Unit 1 and converted it over to gas, which has obviously extended its life cycle.
If the commission approves the CPCN to extend Kentucky Power's entitlement to energy and capacity past 2028, would natural gas conversion be an option for one or both Mitchell units?
It certainly would be.
How much do you spend per year on capital upgrades, normal, like you would with a car or a house? How much do you spend to keep the plant running well?
I'm assuming that I would probably need to go to confidentiality to go over those types of numbers.
Just general. I mean, I don't want confidential specifics.
I would say roughly 20 million plus major projects.
And what would a major project be? What, not a dollar amount, what type of thing would a major project be?
Such as a turbine or something larger that's on a typical life cycle.
Okay. Does Mitchell, where does Mitchell get his coal from?
To the best of my knowledge, the majority of the coal comes from West Virginia now. The larger portion is a high sulfur mine directly across the street, and then the low sulfur comes in via barge.
For the low sulfur coming in via barge, how much out of the money is Kentucky pulling?
I can't state right off. I would assume that Mr. Vaughn could probably give you some better analyses on that.
If Kentucky Power wanted to buy Kentucky coal for its half, could it do that?
I'm sure that, going through the coal marketers, absolutely, if there was coal available, I'm certain that they could probably make that happen.
Are you involved at all in this DOE grant application?
Just at a high level, I know they requested some information for the application, so the site provided that.
How long of a drive is it from Moundsville, West Virginia to Kentucky?
Well, it's approximately 4.5 hours.
Okay, so that's why there's no Kentucky employees there.
Well, I guess I would be interested to know what you're defining as a Kentucky employee. I used to be a resident over here as well.
No, a Kentucky citizen, somebody who pays, state income tax, that type of thing.
Oh, yeah, that would be too large of a commute from that standpoint.
Okay, thank you, sir.
You're welcome.
All right, Sierra Club,
No questions, Your Honor.
staff.
Yes. Could you look at, I guess, figure JDS 3 of your direct testimony?
Okay.
Apologize, I need to pull it up myself. Could you just briefly describe, I know it's in your testimony, just briefly describe what's represented in this table for...
Sure. So these are larger scale capital projects that we've been conducting throughout 2025. Some examples of like the clinker grinder upgrade, which ties into the CCR questions that you asked earlier. That's some advancements there. Lime conversion, winterization, which is typical projects to prep for the cold weather. Diesel fire pump, safety equipment, air heaters, cooling tower repairs, just a wide variety of capital scope.
Does this, because I see the second one from the bottom of the larger chart says all other capital investments.
Mhm.
So does this chart, it has the larger projects kind of set off, but then it has the other capital projects kind of grouped together. Would this represent all capital projects that were allocated on an unequal basis since the 2021 decision in Kentucky to disallow recovery of the ELG project?
Yes, sir, that is accurate.
Okay. And its cost, there's the actuals through April of 2025 and then the forecasted through December of 2025, correct?
Correct.
I'm looking, it's about 4 from the bottom. There's cooling tower reinforcement and cooling tower components. And I won't try to add them up here. Other than, as far as costs that hadn't been incurred, at least as of April 2025, it looks to be about 16.8, or about 15.8 million. Does that look about right to you?
So for the amount that has not been incurred?
As of April of 2025.
Yes, that represents the amount that would come for the remainder of the year.
And I understand that work on the cooling tower ceased when it was determined that perhaps additional work or some other work would need to be necessary. Is that correct?
That's correct. So in July, we, the project team halted the scope of work for the cementing repairs. However, there were sections of rebar or safety concerns from a structural standpoint that continued on until September to get the condition of the foundation of the tower back in a good stable position.
What, are any portion of that roughly 15.8 million, what portion of that hasn't been spent to date? If you know.
I'm gonna say probably close to 7.5 if I were just off the cuff.
Would you be able to provide that as a post-hearing data request if I requested that?
Yes, sir.
Okay. And I believe the projected cost of the kind of larger cooling tower options, those were provided confidentially, so I don't want to go into specific costs on those. But to your knowledge, if Kentucky Power moved forward with one of those options, would it still be necessary to incur the additional roughly 7 million of this amount that hasn't been spent? Or would that money not need to be spent?
Yeah, I believe that there may be some of it for like site tear down and stuff like that when you're wrapping up the job, but in general, the scope of work has completed at this point. We would have to continue with our drone inspections and things like that. So from now until the time that you do some type of conversion or pick which strategy you want to go with, you would have to monitor the cracks and make sure that you don't need anything further. But as of right now, that's correct.
Okay. And monitoring the cracks, would that be capitalized or would that be considered operation and maintenance?
No, we would just do that under O&M, and then if you had to take appropriate action, you would determine what the scope is at that point.
But as of now, that money wouldn't be spent. If something comes up, you might need to spend that money.
That's correct.
Okay. This doesn't include, I guess, capital, well, let me rephrase. I think when you're talking to other council, you mentioned kind of the ongoing annual capital cost of, just roughly 20 million. Would that be something you would incur in most years, or is it something you would incur 60 million every 3 years, or how does that work?
Now, that's more of an annual budget that you have at the start of each year to do capital projects of lower stature. It's going to fluctuate some depending on what your scope's targeted in your long-range plan for that year, but you're always going to have something similar.
And would you have any idea, assuming that the commission in Kentucky didn't approve this ELG project, of that 20 million, a portion of that would be, allocated to Kentucky versus West Virginia? Would you have any knowledge regarding that?
Would you repeat that one more time?
Yeah, I guess just to set it up, this chart obviously shows an unequal distribution of the capital costs, with certain amounts going to West Virginia and certain amounts going to Kentucky. If there were 20 million, say, in 2026, I know that's an estimate, what, if the commission, if the allocation wasn't changed and we continued the unequal allocation, what portion of those capital costs in 2026 would go to Kentucky Power customers versus West Virginia customers?
If we did not go back to 50-50, I believe it's roughly 12%, if I recall. That's off the top of my head.
With respect to the, and I don't believe I'm asking anything confidential, so if at any time something seems confidential, please chime in. I know there were several options that were proposed for the cooling tower. In order for Unit 2 to continue operating from the period of 2026, well, let me rephrase. If nothing is done to the cooling tower, it just as is, we leave it. From 2026 through 2028, could Unit 2 continue to operate, or would not doing something, one of the larger projects to do a more substantial repair on the cooling tower, would that prevent us from operating Unit 2 at some point between 2026 and 2028?
I think during that duration that we would probably be fine. The majority of the repairs that we've implemented at this point would be assessed by engineering through cycles, just to make sure that we're not getting additional cracking or nothing has flawed from a repair standpoint. But much beyond that, I would begin to question, structural integrity, and you'd have to do more assessments again.
And how often do you have to assess it, I guess, could you just kind of explain, is it confidential, what's going on with the cooling tower, I guess? If maybe you could explain it in kind of layman's terms.
Sure. So in general, we've engaged our engineering group to do an assessment and provide an RBTO, which is a risk-based task option. Basically what that is they'll provide you multiple circumstances that you could proceed with. So perhaps one of them is taking down a section of the tower and derating the unit. Perhaps is running as is for whatever period of time they state that the equipment can sustain that. It could be transitioning to a new type of technology, which you guys were talking about earlier, which is a part of that grant process, trying to get some funds potentially to go over to a new mechanical draft cooling tower. That's what they provide to us from a plant site's perspective, the engineering options of what we could choose to do.
And in doing their assessment, I know you said, perhaps it could last to 2028. Have they indicated specifically when they think something needs to be done by?
Not to my knowledge, no. I mean, they stated that the repairs that we've done recently has it in a stable position, but how long will that last, or will things deteriorate? They didn't provide any of that information.
And how often are you inspecting, or how often would you inspect the cooling tower kind of on a going forward basis until a final solution, or until a final determination is made regarding, how to proceed?
Yeah.
How often would you inspect it?
So I know that major projects and engineering team does that. I'm not sure of the exact frequency, but they're still utilizing the drone technology to go up and check things out. So I could certainly follow up and get you specifics. I think it's at least quarterly from the best of my knowledge.
Okay, I might do a post-hearing data request on that, I guess. And do they have any criteria, and maybe this is something for a post-hearing data request, any criteria for when they would determine that it's emergent, there's an emergency, we gotta do something immediately?
Are you referencing from a repair standpoint?
From a repair, or?
I'm sure that they would target some type of length of the crack or depth of the crack or anything that was visibly knowledgeable. At that point is when they would determine whether or not an immediate action was required.
And if something like that was found to where an emergent repair needed to be completed, would you expect that Unit 2 would continue to be able to operate during that period, or would it need to be taken out of service?
To the best of my knowledge, I would think that it would probably remain operational throughout this entire period when they did the repairs previously. At times it was running and at times it was not. Some of the cement type material that's utilized does have curing needs, so temperatures can relate to that, but I don't see why we couldn't run.
Okay. There was a question, if the Mitchell plant was converted to 100% gas, would it be necessary to complete work on the cooling tower?
Yes, regardless of whether we were gas or coal, the cooling tower would need attention.
Okay. And same thing with the ZLD. There was, I think, Mr. Wolfram mentioned that maybe there'd be some compliance requirements, but they might not be as significant if it was 100% gas. Could you kind of explain that? What would be required under the ZLD, I guess 2024 ELG rule, if it were 100% gas versus coal?
So I think the two are going to be very similar regardless of which one it is. I mean, the zero liquid discharge is ultimately stopping that from going to outer sources outside of the facility. So regardless of what combustion source you were utilizing, you would still have to follow that protocol.
Could you just generally explain what's required by, would you understand it if I refer to the 2024 ELG rule and then the 2020 ELG rule?
I do.
what, to your knowledge, was generally required by the 2020 rule and then is required by the 2024 ELG rule?
Okay, so at a high level, the initial rule was where we worked on CCR and ELG upgrades. The CCR is more along the lines of what we did to the bottom of the boulder. You have to go from a wet bottom ash to a dry bottom ash handling system. So we have a submerged conveyor that takes out the product, allows the water to go back into the boiler system, and then takes the byproduct out so that it can be handled and disposed of accordingly. And then from an ELG perspective, we had to reline our ponds, so you had to clean out your ponds and do a relining, and then you have to have a method for processing your water through a wastewater treatment system, which is ultimately what ELG provided by having a bioreactor.
And how did that differ, the requirements of the 2021 rule, how does that differ from the 2024?
So the 2024 rule, the largest difference that I am aware of is that ZLD that you referenced a moment ago, and that's just where you can't discharge any water at all. You have to keep it within a contained cycle.
Okay, so you're still treating it, but then you have to impound the water,
That's correct. You basically just keep it within your system,
including like rainwater? And,
any of it.
okay. Just out of curiosity, how does that work? Wouldn't that accrue over time, and if you eventually have a significant
Well,
water?
some of the water that gets processed through the facility is going to be utilized through steam or disposed of, so you're going to get rid of it some of that way. Outside of that, I'm not certain of the design
Okay.
potentials at this point, so I'm not sure how they would handle an over quantity, if that's what you're asking.
Yeah. How does the would compliance with scratch that actually? Could you explain to me like how decisions with respect to capital projects at Mitchell Plant are decided from your perspective?
Okay.
And
So-
perhaps, I'll cut you off, sorry to cut you off, but if it's kind of different, I imagine it might be different for like, you said your $20 million budget versus, larger projects. You can kind of explain that difference and how the decisions are made.
Sure. So the $20 million budget that we referenced, we call that PPB money, which is plant production blankets. That's your smaller type capital work orders that you're gonna have to do on a frequent basis of like motor change out, pump change out, any common equipment. That is done at the site level between myself and my maintenance superintendent, along with the suggestions of what the operations superintendent requires to run the facility. So we do that mostly internal. We budget that out for a long-range plan on a 10-year cycle. And then outside of that, any project that's like $1 million or higher, we have to work up the process for approvals through our presidents, which would be for Wheeling Power and Kentucky. And you work through Aaron Walker and Cindy Wiseman are the two that we work with on that.
Okay, so anything over $1 million, you have to present them what you want to do, and then it goes through kind of the upper level process that was described earlier, I guess.
Yeah, you give them a high level business case of why you have the need or what's causing the equipment change out, and then you go from there.
And you say you do a capital budget every 10 years? Or do you do it every year, but it's projected out for 10 years?
That's correct.
Okay. I would just probably ask as opposed to hearing data requests just for the most recent capital budget. What about dispatch decisions? Do Wheeling Power and Kentucky Power directly control dispatch decisions? And I guess what I mean, I know you're in PJM, so obviously they're controlling dispatches, but as far as who's deciding when to bid into PJM and when to offer the unit, who is making those decisions?
So we have a prod ops team and a commercial ops team that Mr. Wolfram referenced earlier, that ultimately their group provides the information to our unit operator stating what loading they'd like to have the unit at any particular time. And then, of course, we get day-ahead information trying to give us some bearings about where we'll be for the following day. But I'm sure that Mr. Vaughn can elaborate much further on the specifics of how they get to that.
So you're not necessarily involved in when the unit's dispatched. You're operating the unit and you dispatch it when that team decides that it's appropriate.
That's correct. When we get communication stating that we want to raise or lower or raise loading, our unit operator, respond accordingly, but outside of that, we don't have any say in that.
How does how does the Mitchell plant procure coal? How do you decide how much coal to have on site or how much coal you're going to get in any given year?
So in general, we have a fuels procurement team that will go through and they'll assess the quantity of coal that they anticipate us requiring for that 12-month period of time based on what the markets are looking like. And then they'll set up the appropriate coal contracts to make sure that we have the tonnage on the ground.
Do you play any role in that?
Other than seeing the contracts and knowing what the price per ton is, knowing which vendor is going to be providing it, we have to watch the specs pretty closely because depending on the type of coal, it can give you combustion issues inside your boiler or cause slagging or something like that. But outside of that, they're the ones that formulate the agreements on our behalf.
I think I'm almost finished. I think that's all I have. Thank you so much.
Oh, you're welcome.
Commissioner Wood.
Mr. Snodgrass, I wanted to ask a couple of questions about the CCR rule and ELG rules. Could you generally explain what those rules are and whether or not there's changes to them and what that means for your all's business of making electricity?
So in general, the CCR and ELG rules were federal requirements that we had to respond to make sure that we had the appropriate equipment to treat the water accordingly. And like we talked about with the ash handling earlier, there was a method to take the ash from a wet bottom ash to a dry bottom ash. So we installed that conveying system that takes the product out that allows the water to run off, and then we can landfill accordingly. And then going forward, like we spoke about earlier with the ZLD, that's going to be more stringent requirements where we can't discharge any water off of our site.
And that is what's, is that a change that's being made, or was this just the last year to implement these rules, or how is it that these rules are coming into play now?
So based on what you guys were speaking about earlier, this would be what I would call phase 2 of the ELG requirements that the government is currently deciding how they want to proceed, or do they want to implement those rules. So currently, we would be waiting to see what that ruling stands out. Do we have to make upgrades, or are they not going to allow for that?
So there is a possibility that these rules will be eased or changed or somehow modified going forward, or?
From the government, yes, sir.
And is there any word when that?
I do not know.
Very well, that's all I have.
Commissioner Reagan?
No, that's fine.
Mr. Snodgrass, I don't want specific numbers in these questions, but are you involved in figuring out projections for what your O&M costs are at your plant?
I'll say that one more time.
Are you involved in figuring out what your O&M costs are for your plant? And
Yes, ma'am.
projecting those, okay.
Sure.
Have they been rising steadily?
No, I mean, we had an increase when we had to install some new equipment for the ELG that first passed through, but in general, it's been pretty consistent.
So inflation hasn't been a problem?
Well, I mean, you're always gonna see some inflation in regard to delivery times have gone up a little bit, so freight charges can increase some, and just pricing in general, the responses for other companies have been a bit slower, and that drives up cost a little bit, but it wouldn't be anything that I would call out of the ordinary.
In this case, let's see, the forecast numbers for the first year, is that based on, are you estimating a slight increase from this year, or how did you come to like next year's O&M numbers?
Now, are you specifically talking about the entire budget in general, or what are you referencing?
Just operation and maintenance budget. Yeah, entire operations and maintenance.
So in general, your O&M budget's gonna be based on the amount of time that you think you're gonna run. Obviously, the more you run, the more wear and tear that you put on the equipment, and the more that you're gonna need to invest back into it. So that's the basic concept that we apply when we're trying to determine whether or not it needs an increase going into the coming year.
Okay, it's a forecast number at this point.
Correct.
This year. And it appeared to remain steady, that budgeted amount for O&M over the next 10 years. Am I reading it incorrectly?
In general, it's pretty consistent. I mean, you'll have some inflation cost on certain categories, but for the most part, it doesn't take too large of a step change, no.
I shouldn't feel like they're inaccurate or be alarmed that they don't seem to be going up over the next 10 years.
No, I mean, the only thing that me personally is anytime you get new equipment, it takes a little while to assess how that new equipment's performing, and then you try to identify what you think the useful life is for the new equipment that you installed, and that can, of course, change your budgeting cycle. That would really be the only unknown at this point.
Got it. Your current coal contracts, if you know, are you currently in several long-term contracts?
It's dispersed out amongst both. We have some long-term and some short.
So
Yeah.
some of the short ones could be coming up for renegotiation soon.
That's correct.
And I don't want details. I didn't want to
Yep.
have to go into confidential. Anything further from the commissioners? Redirect.
I have just one question.
Sure.
Mr. Snodgrass, earlier, Mr. Bellamy asked you, and I'm going to paraphrase because I don't remember exactly how he asked it, but essentially, would Unit 2 continue to operate if Kentucky Power or Wheeling Power identified that we needed to do some kind of emergent fix or immediate fix on the cooling tower? And I believe your answer was something like, I believe so. Do you remember that
I do.
change? Okay. Would you also agree that if that, an emergent or an immediate fix were needed, whether Unit 2 could operate may also be dependent upon that situation?
It's based on the severity of what you find. That's why I think at the time I referenced, like, perhaps the size of the crack or whatever you've identified would determine whether or not you need to come out to take actions, or can you do so with the unit in service.
Okay, thank you. That's all I have.
Any recross?
No, ma'am. Thank you.
Any reason this witness can't be excused? Thank you, Mr. Snodgrass.
Thank you.
All right, we have 10 minutes till 12. I had said earlier that we could just do a half hour for lunch, but I think we're moving along pretty good clip. We have 3 more witnesses. I think maybe we could just go ahead and break and do an hour for lunch. Come back at 10 till 1. And then we'll get your final witness and the interveners witnesses. All right, see y'all at 10 to 1. All right, good afternoon. We are back on the record in case number 2025-00175. And applicant, call your next witness when you're ready.
Yes, ma'am. The company calls Alex Vaughn.
Good afternoon, Mr. Vaughn. Would you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Thank you. Please be seated. Tell us your full name and business address, please.
My full name is Alex Ethan Vaughn, and my business address is 1 Riverside Plaza, Columbus, Ohio.
Okay, Counsel.
Thank you, Your Honor. Mr. Vaughn, can you please state your employer and your job title for the record?
I am employed by American Electric Power Service Corporation as the Managing Director of Pricing, Generation, and Fuel Strategy.
And Mr. Vaughn, did you have filed in this testimony, in this case, direct testimony, supplemental testimony, rebuttal testimony, and responses to data requests?
Yes, I did.
And do you have any corrections to those, the testimony or your responses to data requests?
Just my supplemental testimony at page 3. On line 19, the 800 megawatts should say 400 megawatts, and the 2026 at the end of that sentence should say 2027. That's all.
Thank you. And if I were to ask you, with those corrections, if I were to ask you the same questions that are in your direct testimony, your supplemental testimony, your rebuttal testimony, and the discovery requests to which you provided responses, would you give the same responses?
Yes, sir.
I have a couple questions. I know your name, you were here earlier this morning, correct?
Yes.
Your name was spoken freely by many other witnesses.
Taken in vain.
What?
Taken in
I don't know,
vain.
taken in vain, but it was used repeatedly, we'll put it that way, by other witnesses.
Yes, sir.
Okay, do you remember when Mr. Bellamy was asking, I believe it was Mr. Wolfram, about the Mitchell operating agreement?
Yes.
And you remember questions about the uneconomic dispatch of the Mitchell unit, if directed by Wheeling Power?
Yes.
Okay, and are you aware if the Mitchell operating agreement addresses situations where one of the parties were to require the unit to be dispatched uneconomically?
Yeah, that's my understanding, is that the agreement already allows for parties to have the unit dispatched in different ways. So in this example, if one of the parties, the plant dispatched, let's say uneconomically or to some predetermined level, then that could already be accounted for in the agreement, so that the other party to the agreement, the other off-taker, didn't have to participate in those costs. So all of those, we'll call it in this example, uneconomic costs could be contained to one of the participants. It wouldn't affect, in this example, Kentucky Power.
And is your understanding that that allocation of what we refer to here in this example as an uneconomic cost, that allocation would occur at the intra-company settlement process and would not need to be addressed by the commission? In other words, the commission wouldn't have the requirement to go through and figure out what was uneconomic, other than what they normally do. They would, that would be taken care of before the cost even came to the commissioner and the Kentucky Power customers. Is that correct?
That's right. Those costs wouldn't be billed to Kentucky Power in this example.
And then, if you were here earlier this morning, there were some questions from Commissioner Wood about the various environmental rules that are in place, and that there are, and it is very confusing, the status of certain new environmental regulations. Can the 2020 ELG rules, the ones that led to the ELG project that has been constructed at Mitchell, in the bioreactors that Mr. Snodgrass discussed earlier, that rule is not subject to any review by EPA or potential change by EPA, is that correct?
Not to my knowledge, no. The ELG standard that we're discussing in this case for these costs in this application, those rules are not under review. Those rules are in place. The company has complied. Wheeling Power has complied with those rules, and that's how the plant's able to operate to 2028. having complied with that 2020 or ELG 1. The rules that are being considered or reviewed is a second round of ELG rules, or the 2024 ELG or ZLD, whatever you'd like to call it, and then the new MATS standard and the greenhouse gas regulations. Those are the ones that are currently under review.
And then finally, there was some discussion from Mr. Wolfram earlier today about the PJM 2028-29 planning year. Can you describe a little bit about the company's, the timeline for the company to make decisions about the 2028-2029 PJM planning year?
Yes, yeah, so as Mr. Wolfram discussed, as he alluded to, capacity planning is done a number of years into the future. And so as we sit here today, we're preparing to run, submit our plan for meeting our capacity obligations and have the auction run in December of this year for the 27-28 delivery year. So that ends on May 31st of 2028. And then immediately after the first of the year, we begin putting together our compliance with and our submission to PJM for the 28-29 delivery year. And that auction is going to occur, I believe, May of 2026. And so generally speaking, timelines often differ, but we have to have our plans in roughly 3 months ahead of the auction deadline. So that's, it seems like it's a long way out, but really these are decisions we have to be making pretty shortly here for these future delivery years, because that's how the RTO functions, how the company functions from a capacity planning standpoint.
Well, thank you, Mr. Vaughn. With that, Your Honor, I turn, Mr. Vaughn is available for cross-examination.
And for the Attorney General?
No questions.
KIUC?
I do, Your Honor. Good afternoon, Mr. Vaughn.
Good afternoon.
The amount that, the dollar amount you're asking for approval is $138 million?
So just to clarify, yes, the entire catch-up payments, the $138 million, we're asking for prudency on all of that, but the dollars we're asking, the Kentucky Power's asking for recovery today are just the environmental component of that in this hearing.
Okay.
It's a lesser amount than the total, right? Because you have the ELG plant, which is the environmental piece, and then you have the disproportionate capital catch-up.
Okay, but ultimately you would recover $138 million?
Yes, $138 million would go into rates.
So, and if we just look at the 2029 to 2031 period, that would be about $46 million per year?
Oh.
Just divide 138 by 3.
Well, just to be clear, that's primarily capital, and so that's going to go into rate base. Sorry, not just rates. So it's going to go into rate base, and it's going to be depreciated through the 2040 period.
Right, okay. The nameplate of Mitchell 1 and 2, 50% is 780 megawatts.
Sounds about right, yeah.
Okay. But the UCAP, or the amount you get capacity credit for in PJM, is 606 million.
Yeah, that's
606 megawatts.
with that correction, yes, 606 megawatts would be roughly our 50% share.
Okay. Is this a fair metric to look at? What's the most recent known PJM auction clearing price for next year is $330 a megawatt day?
Roughly, yes.
Would it be a fair metric to say 330 times the UCAP, 606 megawatts, times 365 to get a sort of a fair market value of $72.9 million for that 1 year ownership of Mitchell?
That would be about the avoided expense if you had to go replace it. I think it's a fair estimate of that, yeah.
Okay, so
For the capacity portion, right, for that product that comes from the plant, yes.
So 2 years of 72.9 million would pay for the 138 million at issue here.
Yes, sir.
Okay. And with ownership of Mitchell, you get the energy at cost.
That's right. If you're just buying UCAP, you have no call on energy. You pay for energy at the marginal cost in the RTO versus, as you mentioned, getting energy at cost from Mitchell.
Okay. So is that another fair metric to just sort of judge the reasonableness of this transaction?
I think that's a fair way to put it in perspective, that there's a lot of potential cost out there, both short and long term, to replace the capacity from the Mitchell unit, capacity and energy, sorry.
Okay. If Kentucky Power does not satisfy its PJM FRR capacity obligations, what's the penalty?
Oh, gosh. Well, generally speaking, there's deficiency. So there's two different penalties out there if you have an insufficient FRR plan. I can't remember their exact names, but there's one where, let's say, intra-delivery year, you can't deliver from some asset, and you have like a daily deficiency charge. And then there's a separate charge if you file a plan that is deemed to be, essentially you select FRR and you submit a non-compliant plan. There's also a penalty there, and I honestly can't remember the dollar per megawatt day penalty price that has changed recently with the tariff changes in PJM, but it's no small amount.
So non-compliance is not an option?
Non-compliance is not an option, no. We will find a way to comply within our FRR plan or in some other way.
Okay. When the commission turned down the ELG proposal in 2021, what has changed since 2021?
Yeah, I think just the general macroeconomy is different, especially when you're looking at from an energy markets perspective. Demand is a lot greater. Current demand and near-term increases in demand in the market is much greater than it was in 2021. If you remember, back in 2021, we were coming out of COVID. General economic depression, energy prices driven by very low natural gas prices. Energy was very, very cheap from the market in 2020 and into the first half of 2021 prior to the economy and commodities heating up late in 2021. Also, you didn't have the load growth, so you have that demand increase, but you also have a constraint in future supply that we're seeing right now, back to those proposed environmental regulations that we've talked about. So when you couple those two things, there's a real constraint in the markets, which are driving higher prices now.
What about the capital cost of new generation?
It has gotten higher since 2021. And it's driven by those same economic drivers I just discussed, right? So supply and demand. So whether it's for an existing asset or it's for new assets, costs are going up.
The settlement agreement on page 7 deals with securitization legislation. Parties will use their best efforts to securitize. The ELG, the non-ELG costs described in the settlement, along with the remaining net book value of Mitchell. How much money is that?
As we sit here today, I think it would be in the $600 million neighborhood.
Okay.
Yeah.
And so the benefit of securitizing $600 million versus putting it in rate base from a customer point of view is the cost of capital at 100% debt is less than the utility's weighted average cost of capital, debt, and equity.
That's right. The expectation would be if you were able to pass securitization and issue grade A securitization bonds, you would have the lowest interest rate possible. So you would have a cost savings there. The return on component and the revenue requirement would be lower for those dollars.
Also, wouldn't there be a benefit from levelization of cost recovery versus the declining rate-based rate of return where the revenue requirement is highest in year one?
There'd be some of that, yeah. And I think that you could also see a little bit of benefit if you issued 20-year security bonds. I think right now, 20-year securitization bonds. As you sit here today, current depreciable life of Mitchell is out to 2040, so it's roughly 15 years. So you might gain a little lower annual revenue requirement from the difference in term as well.
So the $600 million, essentially, Kentucky Power would be a utility with debt and equity that's $600 million less than it would the day before versus the day after securitization, you would be a smaller utility.
All other things being equal, yes.
Okay, but Kentucky Power would still have full access to the Mitchell plant, the energy, the capacity. It would have to pay property taxes on it. It would still maintain the plant. Everything else is just as the financing would change.
Absolutely.
Okay. And your plan is to take the cash, that $600 million, and use it for new generation to be built in East Kentucky?
Yeah, as Mr. Wolfram stated earlier, that's the company's current plan. I can tell you my team is working with Mr. Wolfram's team on putting that application together, getting that here to the commission and stakeholders. And so when you put all those things together, right, so what you're trying to accomplish this securitization is make Mitchell a lower cost resource, but at the same time add generation. So if you can put all these pieces together, you can come up with a roughly the same size Kentucky Power as you have today, hopefully with a lower cost structure and an additional generation resource.
You would need a CPCN for that new resource, correct?
That is my understanding.
Okay. Would you also consider buying a piece or having a long-term purchase agreement from a generating resource in Kentucky that's owned by a different utility?
I don't want to rule anything out, but we just went through an RFP process where all generators that can deliver power to us were able to bid in. And so we just went through that process. We just evaluated all of those things, and it got us to where we are today. So we never want to foreclose any potential options.
Along the same line, that same vein, would you not want to foreclose the possibility of securitizing additional costs to lower rates for consumers?
So there is a practical and a tipping point with securitization. You can't just securitize everything. My understanding from our corporate finance group is there's a certain level of saturation you can deal with from a securitization standpoint. You can't just have a nonstop amount of bond payments out there, right? Because you do have to have, banks. Part of the process is the banks that will be underwriting these or issuing these bonds, like they do look at probability of recovery and demographics and all of that. So you can't be too heavily weighted in securitization bonds.
That makes sense. Would it be possible as a way to lower rates to securitize X million dollars of distribution rate base?
Potentially, we haven't done that study. I don't know if it's practical, but again, we study a great many things.
And just last question, I think. Distribution, my client Marathon doesn't really pay distribution, their transmission voltage. If you did securitize distribution, it would primarily go to benefit the small customers, residential customers.
That's right. The company's residential and small commercial customers are generally the ones paying distribution costs in their rates.
Thank you, Mr. Vaughn.
Thank you.
Sierra Club?
Good afternoon, Mr. Vaughn.
Afternoon.
I'm Nathaniel Schoaf on behalf of Sierra Club. Can you hear me okay if I speak to you?
Yes, sir.
Okay. The microphone's a little to my left. I just want to make sure you can hear me all right. Okay. I have some questions for you today about your direct supplemental and rebuttal testimony. If any of my questions are unclear or if they're better addressed in a post-hearing data request, please just let me know.
Certainly.
Okay, so in your role at AEP, that work encompasses cost of service analysis, rate design, energy supply costs, and new generation approvals, among other things. Is that right?
Yes, sir.
Does it encompass work on integrated resource plans or IRPs?
So, in executing those duties, my team works with the IRP team fairly regularly. I was a witness in our last IRP. I can't remember if it was the last two IRPs. I'm familiar with IRP work. I myself do not do IRP modeling. Oftentimes, myself and my team will have, we're involved in those input discussions within the company, all the different areas of expertise in the company that feed into an IRP.
Understood, thank you.
Yep.
I have a couple of questions for you just about the background of the Mitchell plant. This is a 2-unit coal plant, correct?
Yes.
And both units went into service in 1971, right?
I believe so.
Okay. That would make these units 53 or 54 years old today, somewhere along those lines?
I believe the chair used that 54-year number earlier today, yes.
Okay, and that means both units have already exceeded their designated useful lives, correct?
I would have to disagree with that. They're still useful till 2040 is the company's position.
Okay. The Chair Hatton asked your colleague, Mr. Wolfram, about capacity factors at the plant. Can you explain to us what a capacity factor is?
Yeah, capacity factor is just a measure of, based on the maximum potential output from a generator, how often it is generating that amount or a lesser amount, right? And so if you were a simple math, if you were a 1,000 megawatt generator and all hours of the year you generated at 500 megawatts, you would have a 50% capacity factor. It's a utilization measure.
And do you know what the Mitchell plant's capacity factor was, say, over the last year?
Not over the last year. If you, I had the last 2-year fuel review here, I had a lot of testimony on Mitchell plant's capacity factor, capacity factors of other PJM coal plants, but in general, it's over the last 10-ish years, it's been in the 40s. I believe it's just generally speaking, Mitchell plant's been in the 40% range capacity factor wise, which has been fairly consistent with its RTO peers.
Chair, I have a demonstrative exhibit to show the witness. Sorry if I approach and share the files with him?
Yes.
Okay.
Thank you.
That's all right, here you go.
Mr. Vaughn, I'm going to plug this in and hopefully this will pop up on the screen so that everybody can see this document, those that did not get a copy. Well, that may not work, actually. You have a copy in front of you. I think you should just proceed with questioning. If it shows up so that the rest of the gallery can see, that would be great. But, would you agree with me, Mr. Vaughn, that for the first part of this decade, if you look on page 2, those years, let me just back up. Part of what this document shows from S&P Global are the annual capacity factors for the Mitchell plant for the first 24 years of this century. Do you see those columns to the right labeled capacity factor?
I do.
Okay. Would you look at page 2, please? And as you look at those years towards the bottom on the right-hand column, labeled 2001 rather to 2010, would you agree with me that in the first decade of this century, the Mitchell plant operated with an annual capacity factor usually in the 50s, 60s, or 70s?
Yeah, certainly the lowest listed capacity factor in this document there is 49.46% in 2005.
And those relatively high capacity factors indicated the plant was competitive in the energy market at that time, correct?
I'm not sure you can draw that exact conclusion. I think what you can say is that its marginal cost to generate, its variable cost to generate on average was lower than the marginal cost in the PJM RTO, which is what it was dispatched into economically during that period of time.
Okay. And if we turn back to the first page and look at the years 2019 through 2024, would you agree the plant has not exceeded an annual capacity factor of 40% since that time?
I mean, that's what the numbers are, but again, you have to think about the reasons why. And so you stopped arbitrarily at 2010, and so it's about the time that hydraulic fracturing became prominent and the supply of natural gas was greatly increased and the cost of natural gas in the economy went way down. And so everything prior to that, you're looking at a different gas market, a different regime. And so generally speaking, the PJM RTO, the marginal cost of energy is set from a combustion turbine unit, about a 10 heat rate. And so the cost of natural gas versus the cost of coal is going to drive that, right? And so you come over here onto the second page, which you correctly observe the capacity factors are lower, right? And again, same economic dispatch theory, you just have a different price of gas, a different price of coal going into that over this period of time.
Okay, but you agree at least for the last 5 years, we have not exceeded this 36.89% capacity factor?
That's what these numbers say, you're right. And so when I was saying around 40 earlier, my testimony in the 22 fuel 2-year review was looking back the 10 years prior to 2022. So earlier in the teens, there were some higher capacity factors achieved. So,
Okay, and you would agree with me that this 30% capacity factor is a fairly low capacity factor for a coal plant?
I mean, compared to what?
Compared to other coal plants?
No, I think we've presented evidence over and over again that Mitchell, and again, I haven't done this for 24 and 23, but we've evaluated Mitchell plant and the other coal plants that the AEP operating companies operate in PJM versus, you go out there to the state of the market report and the market monitor will show you by fuel type what the average is in the RTO. When you look at a plant specifically, you got to take into account what is the availability factor of that plant. So what did it have major construction outages that year? Was it installing ELG and CCR? All of these things go into the realized capacity factor for any one generating unit, coal, gas, anything else. You need availability is a key metric, as well as economics.
Part of the reason the Mitchell plant hasn't exceeded this 40% capacity factor and is now down below 30% is that it's less competitive in the PJM energy market than it used to be. Is that correct?
Can you define what you mean by competitive?
Well, if it's operating more at a 40%, that suggests to me that it's more competitive with other sources of generation. If it's operating below 30%, maybe towards 25%, then it's less competitive than it was when it was at 40%.
See, I don't necessarily view it that way. So you got to think of what the Mitchell plant provides in at least two different products, right? So it's supplying the company with the capacity it needs to meet its reserve margin requirements, and then it's giving the company's customers the option of the lower of cost to generate or market, right? So as we discussed, we're always trying to find the lowest cost for our customers. So if we can achieve a lower variable cost from purchasing from the market, we're going to do that. And so it's providing optionality. It's not necessary. It's not an IPP. It's not competing for gross margins of some sort. It's trying to provide customers with that physical hedge on market prices so that when they do spike, it is there. And I think if you looked into the monthly profile of how it goes into these capacity factors, you're going to see that it's going to run a lot more in the summertime and the wintertime when the natural gas prices go higher, loads go higher, LMP prices go higher. So you're avoiding a higher purchase from the market.
And in general, utilities should avoid making long-term investments in aging and inefficient resources. Would you agree with that?
No, I wouldn't agree with that.
One problem with making long-term investments in aging and inefficient power plants is that a utility might be required to make even more investments further down the line to keep the plant operating, correct?
So I think you're trying to misconstrue the age of the plant with kind of its operational age. Talking with Mr. Snodgrass, sure, it is a 54-year-old structure, but through capital renewal, maintenance, capital investment in that project, in that plant, there are very few 54-year-old pieces of equipment left in that plant. Right? That's just how machines work. You replace them over time.
In your discussion with Mr. Kurtz, you mentioned a new resource, CPCN. We can put this document aside, we no longer need it.
Okay.
Big picture, I'd like to get a sense of where this CPCN and this docket fits into Kentucky Power's upcoming filings before this commission. The company's last IRP was in 2023, so you'll have an IRP in 2026, correct?
I don't know the timing of the next IRP.
Okay. You'll have a CPCN for whichever cooling tower repair project is ultimately selected here, correct?
That's my understanding, yes.
Do you know when that's going to be filed?
Not specifically, it will be sometime in 2026.
Do you know if that's expected to be filed in the first quarter, second quarter, third quarter, something else?
I would say it's probably likely that it will be filed the first half of the year.
And if you know, Kentucky Power files a CPCN for the cooling tower repair in the first half of 2026. Should customers, ratepayers expect that Wheeling Power will also file a CPCN with the West Virginia PSC along those timeframes for the same project?
So that's my understanding, is that Wheeling will also seek a CPCN for that project, and so when we prepare that, it would be prepared for both companies.
Yeah, and just so I'm clear, both companies are affiliates of AEP, yes?
Yes, they are wholly owned subsidiaries of AEP. They are affiliate companies.
Okay, so AEP has some say in whether or not those companies file those CPCNs?
I mean, AEPSC provides professional services. We advise. So, Company President Wiseman and Company President Walker for Wheeling, they're making that decision. They're listening to the same technical experts that we're talking to when we're looking at costs, right? So we have one set of shared, engineering experts who are advising them on this project. They're advising others on other projects, right? So it's a cost efficiency, but ultimately those company presidents will make that decision as to how we proceed, and then they will ask their shared resources to make that happen for them.
Okay, and I believe in discovery response to staff 4-4, that was just filed last week. You indicated that the company expects to file a CPCN for a 450 megawatt natural gas simple cycle combustion turbine at Big Sandy in the first quarter of 2026. Is that right?
That is correct.
Okay. So that's 3, and it looks like a 4th to me. There'll be a CPCN associated with, at some point, whichever post-2031 environmental compliance plan that those identified in your testimony as alternatives E1 to E5 that the company ultimately opts to pursue. Is that accurate?
Potentially, right? We don't know what's going to happen with the regs that the EPA has indicated they're revisiting. Right? As we've had some of these discussions earlier, if those regs are pushed out or go away entirely, right, you may or may not have, there may not be a need for any of those alternatives shown in the post-31 analysis in my direct testimony.
Right, fair. Yeah, I get that changing regulations may change that. Do you have a sense of when that decision is going to be made? Is that going to be made prior to 2028? Is it going to be made in 2031? Will it be part of a 2026 CPCN?
Are you asking me when I know if the EPA is going to make its decision, or when we would make decisions?
I'm asking when the company intends to make the decision.
So there's a current compliance. This is a very interesting scenario, right? So you have current law and you have current deadlines to make decisions, and so that's why the company has run the analyses it has, and it is waiting for more guidance from the federal government on what's going to happen with the rules that they have publicly noticed they plan to either push back or repeal altogether. And so we're always we're always trying to act prudently with the information we have, and unfortunately, we just don't know what we don't know at this point.
Okay. Are there other CPCNs that I haven't just identified that you know the company intends to file with this commission in the near term?
Yeah, I don't know if there's a transmission CPCN or some other distribution project that would require them to file a CPCN. I don't know.
But no other new generation CPCN that's on the very near-term horizon?
Not that I know of.
Okay. And then when the company applies for a CPCN in 2026 for the cooling tower, I believe you did indicate that that is coming sometime in 2026.
Yes, that's my understanding.
Okay. If the commission denies the request to extend the ownership interest in this docket, could the company come back in that 2026 CPCN and ask that that relief be included there?
Potentially, I don't know what the company would decide to do, what President Wiseman would choose to do, or what President Walker would choose to do. I mean, we've come here to get caught up and provide customers with the lowest reasonable cost alternative for 28 through 29. As I discussed earlier, if they don't make a decision here and Kentucky Power does not have entitlement to the energy and capacity off that unit for the upcoming planning years that we have to commit our plan for in PJM, there will be additional cost to customers. And I think, Mr. Kurtz threw a fairly reasonable estimate of what those costs would be based on current market dynamics.
Okay. I want to change gears and ask you about the economic analysis that was done in this case. The company didn't conduct capacity expansion modeling, did it?
Which economic analysis are you?
The economic analysis that you identified in your testimony as supporting the CPCN in this docket.
So the direct testimony options 1, 2, and 3.
Yes.
Yes.
And any of those future compliance options, E1 through E5. The company did not conduct capacity expansion modeling, did it?
No, it would not be appropriate to do so there, especially for the near term. Right, the table 1, alternatives 1 through 3, we could not have had additional new resources online in that time frame. So capacity expansion modeling is a pointless exercise in regards to that analysis.
But it also wasn't done for the post-2031 analysis, was it?
I would disagree with that. So not a full IRP was run, but the company's environmental experts and IRP team all sat down with what the environmental options would be for compliance with the environmental regulations. So what are the compliance options for the Mitchell plant? And then based on modeling we were doing, capacity expansion modeling for other filings, we were looking at what is the cheapest alternative, and that is essentially, if you're just looking at the generic new resource options out there to replace something of this magnitude, what is it? It's a new combined cycle plant. So that option came into the analysis through capacity expansion, and then we used our capacity expansion model, Plexos, to model the dispatch analysis of all of the options in the post-31 analysis. And I believe we indicated that in discovery multiple times.
And if we submitted a post-hearing data request on where in the record that information exists, you could point us to it?
Yeah, I believe it's in my direct testimony and in data responses. Yes, we used Plexos to model the dispatch of all the post-31.
And did the company conduct production cost modeling?
Yes.
And where in the record is that?
I believe it's in our answers to our data requests. So we did the production cost modeling in Plexos. And so we looked at what is the new operating profile of the engineering team, worked with the plant team to come up with, hey, if we did 40% co-fire, if we did 100% gas conversion, what operating characteristics of the unit would change? So is the heat rate going up or down? Is the up or down time changing? Does the ramp change? Does the minimum downtime change after a shutdown or a startup? And all of those variables for each option were fed back in to the Plexos model, including the company's fundamental commodity forecasts. And then Plexos did the production costing, dispatched it against the assumed market prices, and that's how we got to the energy margin portion of the post-2031 analyses.
Okay, let's look at those near-term options that you identified, those three. If you open your direct testimony, I should have asked before, do you have your direct testimony in front of you?
I do, sir.
Okay,
Yes.
I figured you did, but would you go to page 4 of your direct testimony?
Certainly.
So on page, are you at page 4?
Yes, sir.
Okay, so you see those 3 bullets on lines 13 to 17. Those set out essentially 3 options for the near term for the plant, which would be continuing to receive power from Mitchell, PPAs based on a 2023 RP, and market purchases. Is that accurate?
Yes, sir.
And then if you look at page 8 also of your testimony, there's a table there. It's labeled AEV1.
Yep. Summary of the costs.
Those costs are roughly $335 million for alternative 1, $471 million for alternative 2, and $895 million for alternative 3. Is that accurate?
That is correct.
Okay. And for those, for alternative 1, where you continue taking power from Mitchell, those costs increase based on the revised and updated costs for the cooling tower repair. Is that right?
So not in this table.
Yeah.
So table 1 in my direct testimony, it does not include the roughly $5 million a year reduction you would see based on the settlement agreement, right? Because this is our as-filed proposal with a different amortization period of the ELG catch-up payment. So option 1 would be about $5 million a year cheaper under the settlement agreement. And it also does not include any additional cost for the potential cooling tower replacement options. Those are included in my supplemental testimony in one of those tables.
Right. I mean, I don't mean to suggest that information is already in this table. I just mean those increased costs impact alternative 1. Is that accurate?
Yes, sir.
Okay. Now for the power purchase agreement, this alternative 2, I believe you stated in your testimony, well, let's just look at at your supplemental testimony on page 9. You have that in front of you?
Yes, sir.
Okay, so page 9 of your supplemental testimony. On lines 7 to 9, this is towards the bottom of the page. You write, one should keep in mind that alternative 2 from my direct testimony utilizes dated PPA information that the company believes to be lower than today's market for PPAs. Did I read that accurately?
Yes, sir.
Okay. How much lower?
I can't give you an exact number, but what I can tell you is that when you look through the timeline of the RFP bids from the late 2023 RFP, right? So we got the bids in, and we generically say RFP, but it was multiple RFPs. Remember, there was storage, intermittent, and thermal resource RFPs. And so we brought to the commission last year the most economic project out of the intermittent, the Bright Mountain Solar Renewable Energy Purchase Agreement. While that was going on, and so we separated them out into different filings purposefully, because while we were evaluating that and determining that Bright Mountain was the most economic choice out of the intermittent RFP, the EPA regs hit the Federal Register, I believe, in April of 2024. So that would impact the thermal bids. So our commercial team contacted the bidders, asked them for updated quotes, and so they had a number of days to update their bids for that in late 2024. And so then we began reevaluating those costs, and we saw a sharp uptick in cost based on from the initial bids to those refreshed proposed environmental, or no longer proposed, enacted environmental rules, right? And so subsequent to that, you had additional capacity market clears that went from $220, about the same time they were bidding last year in 2024. Capacity market had cleared for roughly $220 a megawatt. Since then, we've had a capacity auction clear go up to the cap of $329. So it would stand to reason that those bids, if refreshed again, would go higher. To the extent, as I mentioned, some of the resources that were bid in that RFP have since been sold to other parties. So we don't even know if they would be willing to bid into an RFP if we went back to market. So I don't have an exact answer for you how much lower, but the answer is I'm confident those RFP prices are lower than today.
All right. But the information on how much lower, it's not somewhere in the record, right? It's not that you just.
It's not, but even if it's $5 lower or it's $10 lower, the option one Mitchell cost of service is still by far the lowest reasonable cost for our customers compared to those PPAs.
Okay, let's talk about an alternative that the company could have but didn't consider. Your colleague, Mr. Wolfman, today noted that the prior order, at least in his view, didn't require divestiture of ownership of the plant, just that the company stopped taking power from the plant. Here, the company didn't consider an alternative where it would purchase near-term power from Mitchell but not retain its ownership interest, did it?
Can you explain that again?
The company did
Rephrase
not
your
consider an
question.
alternative here where it would A, purchase near-term power from Mitchell and B, not retain ownership interest.
So you're saying, your question is, did we consider purchasing
PPA
through a
with-
PPA from Wheeling the energy and capacity from Mitchell?
Yes.
No, we did have those discussions. I believe I talked about it in my rebuttal testimony, and the indication from Wheeling is that it would be for the cost of service of Mitchell. So you get to the exact same cost that's in my alternative one in table AEV one for 2029, 2030, and 31. So there's no advantage to our customers of doing so. All you're doing then is creating an issue where you've purchased energy for those years, you don't have optionality on the plant, and you now have to replace it with something that's going to be higher cost.
Yeah, I believe in your rebuttal testimony, you said entering into a PPA with Wheeling Power would be the same as alternative one.
For those years, yes, 29 to 31.
Is it typical for a power purchase agreement to include future environmental compliance costs and obligations similar to having a 50% ownership in a plant?
Yes, if it's a regulated deal between two companies, why would the ratepayers of West Virginia subsidize the ratepayers of Kentucky, right? They would have all of those costs on Wheeling Power's books. They would ask Kentucky Power in this hypothetical short-term PPA to pay the full cost of service of all the costs to own and operate, produce power from that share of the plant.
So I'm trying to understand what the trade-offs would be here of that kind of alternative, which Sierra Club has proposed in our direct testimony. In the short term, I hear you saying that they would provide the same benefit to the company and its customers with a similar amount of power for a similar price. Is that right?
I'm sorry, can you repeat your question?
All right, so the trade-offs there, under this alternative, where you enter into a PPA with Wheeling for power in the near term, say 2029 to 2031, for the company and its customers, they would get a similar amount of power from it for a similar price. Is that right?
Yes, that's my testimony.
Is that demonstrated in the record here?
I'm telling you in my testimony and today that we discussed this with Wheeling Power, and they indicated that yes, it would be for cost of service, right? They have to answer to a Public Service Commission as well as Kentucky Power does. So there's not going to be a discounted PPA under some sort of scenario here.
Okay, but so the benefit to the company is that you would get this power, but in the long term, there's a difference, which is that at the end of 2031, you'd need to secure additional generation, correct?
Yes, and to do so, you would begin working today.
Yeah, you'd have 6 years to develop a plan and secure new generation from 2025 to the end of 2031.
Yeah, I mean, that's our, if
But you
you're
also-
looking to bring a new plant online,
Yeah.
you start today to hit 2030, 2031.
But you also wouldn't be obligated to pay for those ongoing costs of a 55, at that point roughly 60-year-old coal plant, correct?
Again, I'll kind of disagree with your contention that it's, yes, the structure is that old, the plant has been in service that long, but again, capital renewal, investment in the plant, not everything inside that plant is 55-plus years old at that point.
Okay, let's look at the cooling tower repair options from your testimony. For the cooling tower repair options, the company here has identified 4 options. I believe this is page 2 of your supplemental testimony.
Yeah.
I'm sorry, it should be page 3 of your supplemental testimony.
I was in the wrong testimony. I'm get in there. Yes, page 3.
Okay. The work was paused in July of 2025. I think that's what your colleagues previously testified. Is it still paused?
Yes, sir, you're correct that it was paused in July of 2025, and it has been mostly finished, to my understanding. I believe Mr. Snodgrass discussed that a little earlier as well.
Sorry, when you say mostly finished, what do you mean by that?
The project itself that was paused, right? So there's equipment up on my understanding from talking to Mr. Snodgrass and the engineering team is you had equipment up on the tower to do the work, and so that there were, as he discussed, there were rebar repairs and things that needed to be made. Those were completed. The we can call the shell reinforcement was not completed. That is the part of the project where the scope upon it was discovered the scope of those repairs were larger than initially anticipated. That part of the project was paused and subject to further reevaluation here in these four options. But my general understanding is that the project essentially is done, right? So that project has been stopped.
Got it. That's the project that's been stopped.
Yes, the original project.
Gotcha. How long, so in the current state that the cooling tower's in, how long can it continue to operate safely?
I can't answer that. I think Mr. Snodgrass said earlier that our understanding is that and this is my general understanding as well, we've done some of the same meetings, is that it doesn't have an emergent issue where it is, just to be clear, it is under continuous monitoring. There's continuous monitoring on it. There may not be a drone flying up there all the time, but there are systems on the cooling tower provide the engineering team with continuous data monitoring of the cooling tower structure. And then no one knows how long it will operate safely and reliably in its current state, but the engineering team has recommended that something be done to address the issues going forward, and these are the options that have been provided.
Okay. I would like to ask you just a couple of questions about costs. I understand that's confidential.
Sure.
Chair, at this point, I would like to enter into a confidential session.
Candace?
Yeah, we do, if Your Honor, if we could take a moment to make sure that the people who remain in the room have executed an NDA, I'd appreciate it.
If there's anyone in the room who has not executed an NDA or is commission staff, ask you to leave the courtroom at this time.
Based on my review as well, I think we are good to go.
Thank you. Okay, we've been off in confidential session to ask the witness questions based on the confidential record, and now we are back on the public record. Mr. Schiff.
Okay, thank you. Mr. Vaughn, just a quick question about the timing here. I believe your rebuttal testimony, excuse me, that was filed November 13th of this year, is that right?
Sounds correct, yes.
Okay. And the decision we were just referencing was made on November 6th?
Yes, sir.
Okay. But your rebuttal testimony doesn't address this particular issue, does it?
No, there was nothing to rebut on the issue.
Okay. All right, let's switch gears. I don't have very many more topics for you. On the effluent limitation guidelines, for what I'm calling the 2024 ELG rule, there's been some discussion today about what that requires with regard to coal plants. If Mitchell were to convert 100% to gas, would it need to comply with the 2024 ELG rules zero liquid discharge requirement?
Great question. Nuanced answer for you. So the plant operations would not be complying with ZLD, is my understanding, but you would still have some compliance dollars at a much lower amount for the discharge from the existing impoundments on the Mitchell plant site. So there's ash ponds there that are subject to the ELG rules today, and my understanding from our environmental and engineering teams is there would still be some expense there, and those expenses are included in alternative E3 in the post-2031 analysis. But I guess to answer your question more directly, the ELG, 2024 ELG costs are much lower under that option than the options where you continue to burn some level of coal.
Can you tell us, thank you for that, I appreciate that not every answer can be yes or no. Can you tell us what those costs were that were included in the analysis for E3?
Off the top of my head, I don't remember the exact amount. It's in the work papers that we've provided in here. I want to say it was, I just don't know. I don't want to quote you something wrong. It's much lower. It's included in the work papers we provided in AG 1.1. Response to AG 1.1, there is a detailed work paper for all of these scenarios, including the incremental capital cost and the new operating cost profiles of each compliance option.
Well, we will look at AG 1.1 in the response, and if it's still unclear, we will ask a post-hearing data request about that.
Okay.
Okay. Let's talk about the long-term plans and these environmental compliance options. In your direct testimony, you described 5 future potential plans for the plant. These are labeled E1 to E5. Is that accurate? And if you look at your direct testimony on page 10 is where these are set out.
That's right. I just want to be clear. Like E5 isn't, E5 as we indicate is like if the regs were to be rolled back, postponed, or completely rolled back, right? Really, if you're assuming the environmental regime stays in place, it's really options E1 through E4.
Okay. And with regard to E3, this is convert to 100% gas to comply with the GHG rule with no retirement date.
There's no set retirement date with that option, correct?
Yeah. And that analysis includes the zero liquid discharge requirement to comply with the 2024 ELG rule. Is that correct?
Yes, sir.
And that's that, I believe, what you call the nuanced answer, where we're looking at some existing impoundment costs.
Yes.
That we'll be able to identify either through AG 1.1 or a supplemental request.
Yes, it's a reduced amount of compliance cost.
Okay. Your rebuttal testimony addresses Sierra Club witness Glick's testimony in large part. Is that accurate?
Yes, Sierra Club witness Glick and Mr. Collins' proposals on cost recovery.
In Ms. Glick's testimony, she states that EPA estimates the updated, so this 2024 ELG rule will require more than $50 million in additional costs at Mitchell. Your rebuttal testimony doesn't address that point. Do you have any reason to doubt that estimate?
No, again, I think the actual amounts are included, or actual current estimates are included in those work papers for E1 through E4, but I don't have any reason to doubt that number.
Do you know what the 2024 ELG compliance cost would be at Mitchell?
Not offhand. Like I said, it's in my work papers. There are incremental capital amounts in there, and then there's operating expenses associated with ELG compliance as well. All of that is included in the work papers.
Okay.
And the analyses and the summary tables in my testimony.
When you say work papers, just so I'm clear, when we go back and look, is that AG 11 or some other work papers?
Yeah, so when you look at the response to AG 11, there's about a dozen Excel spreadsheets in there. I think there's some sort of index provided as well as to what each one is. Yeah, there is a Excel workbook for each one of the options, and there's associated other inputs in the work papers there as well.
We will look at that, and if we can't find it, we'll ask in the post-hearing.
There's a lot of Excel there. Best of luck.
Mr. Schoaf, if I might point you out, staff 4.2 includes the, like a better, the table of contents for what the work papers are.
Thank you. Staff 4.2 is the one that was just filed last Friday.
Yeah.
Okay.
That was courteous, Mr. Gish. Thank you.
It saved us a lot of time.
We're here to help.
That is handy.
All right, just a couple of other questions. In the long-term analysis, which is what we're talking about here with these environmental compliance options for the plant, did you compare the cost of continuing to take power from Mitchell operating on coal to an alternative where the plant converts to 100% gas and does not install any zero liquid discharge system?
Can you ask your question again, so I'm clear?
Okay, so, yeah, for the long-term analysis where you're comparing these alternatives, alternative E3 is the one where you convert to 100% gas, but that includes a zero liquid discharge system cost. Did you do any analysis that would have compared the cost of the proposal that the company would like to go forward with to a scenario where the plant converts to 100% on gas, as it does in E3, but does not install a zero liquid discharge system?
So what's included in confidential table AEV2 is the three alternative E1 through E3 are the compliance options for Mitchell, which our environmental experts provided to me as here are compliant options for the MATS 2024 ELG and greenhouse gas rules. And within those are their estimates of our cost to comply. So when you say no ZLD, they advised we had some sort of ZLD cost. Like I said, it's much smaller amount because it's not on the operations of the plant. It's on the existing impoundment costs. So all of those compliance costs and estimates are included in E1 through E3. E5 is provided as an estimate of, business as usual for the Mitchell plant with its current, at the time we filed the current capital forecast, capital and operating O&M budget for the plant out through 2040 to show how those alternatives compare to business as usual, if you will.
Okay, I believe the answer to the question was no, but I want to make sure that that's your testimony.
So I didn't study any scenarios that my environmental team told me weren't compliant.
Okay.
So I have to lean on their subject matter expertise. So when they tell me there are some ZLD costs in a 100% gas conversion, I have to defer to them on that.
Okay.
I run the economics. They tell me how to comply with environmental regulations.
Everybody answers to somebody. All right, I just have a couple other questions for you. In the discussion today, there's been a lot of talk about uncertainty at the federal level, which you yourself have referenced. There was talk of on-site oversupply issue with coal and coal contracts leading to uneconomic dispatch of coal plants, and the incremental cost of handling coal combustion waste, either through the CCR rule and the ELG rule. If you were to convert this plant, Mitchell, to gas, 100% gas, don't you avoid this regulatory uncertainty, the coal oversupply and on-site storage issue, and having to address any of what you do with these incremental costs of ongoing coal ash?
So yes, there are trade-offs, and there are things you no longer have to manage. You're like I said, you're still going to have to manage the current ash impoundments and all of that that's on the property. That's included in that. There is a different operating expense profile. So yes, you may not have to. You wouldn't have incremental coal ash handling, right? And that's reflected in the option. Right, I just want everybody to understand, though, it's not a convert it tomorrow thing. Right, there's other things you would have to do. Right, you would go out. These are estimates based on what we knew at the time. You'd go out, you'd rebid, you get new estimates. You would have to do an RFP to have gas infrastructure installed. Like, yes, you wouldn't have costs of coal anymore. You would have costs of gas as fuel. So, totally agree. There are trade-offs in what your cost drivers would be at that plant if you changed its configuration to run off of 100% gas.
Got it. And you agree that that would avoid this regulatory uncertainty that we're in right now?
If by regulatory uncertainty you mean the 2024 ELG and greenhouse gas regulations, then yes, if you made the plant compliant, you in theory wouldn't have to worry about what happens with compliance.
Yeah. And that on-site coal storage issue, where in order to avoid the contractual penalties, the coal plant has to operate in an uneconomic manner, you'd avoid that too, right?
I want to be careful about how we characterize the on-site storage issue, right? Because there's times, so when gas is really cheap, you can view it as, all right, well, I can only fit so much coal on site, and you have to contract forward. And yes, there's a carrying cost for having more coal on site. But then, as we saw in 2022, when gas gets really high, or you have a commodity spike, that coal on hand can be very valuable and can provide the customers a lot of benefits. So yeah, there's gives and takes.
Mr. Vaughn, we've been at it for a while. Thank you for your candor today. I really appreciate the discussion we had, and I don't have any further questions for you.
Thank you.
Staff?
We do have some questions. We need to just swap out the thing. We can use that.
Does this have a name?
I don't know.
It could have gone worse.
Just was going to help me with that. Public attachment, page one, public attachment.
Want to draw off the header? You just want me to display?
You can.
Can we check it?
Yeah, I apologize.
No, it's okay. Do we need a little break?
Maybe that would be good, and
Yeah.
get Jim to get
I was
set
gonna wait
that
about
up.
20 minutes and take one, but yeah, let's take a 10-minute break.
Thank you.
Then maybe we can finish it.
Thank you.
All right, we are back on the record, and I think we're ready for staff cross.
Yes. I just want to talk about some of the short-term alternatives really quick from table AEP1. And this is, I think, a work paper that was provided in response to the Attorney General's first request for information. And could you confirm that that chart here in this first tab is a recreation of the table AEB1 from your direct testimony?
Yes, sir.
Okay. So I'm looking at alternative 3. Let me see. If you go to the market tab,
Scroll left.
yeah, scroll left. And then scroll up maybe. So there at the top, that's the, it shows the projected generation for Mitchell 1 and 2, revenue for Mitchell 1 and 2, and then the total generation cost for Mitchell 1 and 2. Is that correct?
Correct.
And the total generation cost, that's the variable cost of generating energy from Mitchell 1 and 2.
Yeah, so that's what you're looking at there is a summary of Plexos production cost modeling output. So that is the Mitchell units bid economically against simulated market, and them dispatching economically. Those are the total variable costs. So fuel, any sort of emission allowance, and scrubber reagent costs that are included in the variable production of power versus the market revenues.
Okay. And you kind of did just list off the few. What could you kind of just quickly go through and describe the types of costs that are included in that variable cost that you would look at to determine whether or not the energy is economic?
They put me up after bond for some reason, I don't know why.
Oh, what?
I think we all heard that. So.
Someone's what?
Everyone heard that, right?
Yes.
What did we hear, though?
Super.
What did we hear?
Someone on?
Someone on Teams.
I think it was Lane rejoining Teams. Is what I was
Okay,
saying.
okay, no worries. Okay,
Someone can mute him.
all right.
Can you
Could
repeat
you
your
just
question?
briefly describe the types of items that are included in that variable cost of production?
Yeah, certainly. So variable cost of production is, of course, fuel. So in this instance, it'd be coal expense. Some measure of fuel handling should go in there as well. Then you have scrubber reagent costs. So there's various chemicals, limestone, Torona, potentially urea. Just depends on the plant and the scrubber. But there's different chemicals that go into the scrubbers that you have to that vary with the amount of electricity you produce at the plant. And then there's potentially emission allowance costs. So like during summer NOx season, there's the cost of emission allowances to cover emissions from the production.
And for this calculation, how did you estimate those costs for the purpose of running this kind of production cost modeling?
Yeah, so full disclosure, I asked the experts that do the production cost modeling to do this for me. And those costs were developed based on, in this short term, so it's going to be any contracts we have for those items, whether it be coal or reagents, or then market curves and other forwards for such products. So it's a mix of contracted and available market intelligence, if you will, forecast.
With respect to the fuel prices, I'm assuming you started with kind of your current contracts for fuel prices. Is that accurate, or do you know?
Yeah, right, so it depends on the term. If you're looking at 25, 26, 27 on here, obviously you have coal under contract, and so yes, you're using the actuals. And so then our experts in fuel procurement, the folks at the plant, the commercial operations people, they all get together and look at what are the markets for these products look like, where are they trending, what are they seeing, what is the supply and demand, and they come up with how the forecast goes from, how does the forecast trend from actual costs you have under contract to forward?
And when I meant started, that's what I meant. Like, in the early years, you're kind of tying it more closely to your current cost, and then you're projecting changes out into the future. And that's what that team did.
Yes, sir. You're only using estimates when you don't have actuals.
So with the revenue, how did you, well, I guess let me just kind of start here. How do you determine, it basically is going to compare the variable cost against the cost of energy in the market, and if the variable cost is equal to or less than the cost of energy in the market, then the production cost in this situation would have dispatched Mitchell. Is that accurate?
I think it's accurate, but it's very simplified, right? So the production costing is looking at it, it's not just a spreadsheet exercise. It's looking at the actual operational parameters of that unit. And so if it can only ramp X megawatts an hour, that's taken into account. If it has a min downtime of 3 days after it's been dispatched, so if you turn the unit off for economics based on the forecasted LMPs, you can't turn it back on for 3 days. So it contains all the same operational constraints. You can't just turn an 800 megawatt coal unit on and off hour by hour in a spreadsheet. Well, you can do it in a spreadsheet, you can't do it in the real world. And so the production costing reflects that. And so what I'd also like to point out, like here on the market tab, what this is doing is it's using the market revenues there, which is the forecast for LMPs at those times, as the replacement cost of energy, right? Because if you don't have Mitchell, you're buying at market. You're buying at LMPs. And as my direct testimony states, it says that for the market option, we replaced the same amount of energy that we expect to get from Mitchell to make it apples to apples. So that's what you're seeing here in this work paper.
And I get that, and I appreciate that explanation about the operating parameters, being reflected, and I kind of understood that. I guess to get into more detail, like, was when you did the production cost modeling, or when they did, was it looking at it on an hourly basis?
Yes, sir.
Like every hour over what period of time did they use? Did they do this full period of 2025 through 2035?
Yes, sir. This run here is a hourly dispatch analysis from 2025 through 2035.
Okay.
Yes. So a 10-year production cost run.
And how did they determine the market price to compare against the variable cost of energy to determine dispatching in this scenario?
Which market price? The LMP price?
Yes.
Yeah, right. So again, we have, I think we answered this in Discovery, but we have fundamental views, so fundamental forecasts, and then we have short-term production cost modeling here. So typically the way the forecast for LMPs works is you start with a price for natural gas, right? So what are you pricing? So in this case, probably some sort of liquid trading hub like AD Hub, the AP Dayton Hub, PJM RTO electricity, right? And then what is your cost of natural gas over this time period? And then they're running a simulation of the market and what is the estimate of the marginal unit setting LMP based on demands over that period of time. And like we generally see in the PJM RTO and LMPs today, it's a 10,000 heat rate gas unit about under certain demand scenarios times the gas price is how you end up with LMP. Simplifying a very complicated thing, but it's a combination of supply, demand, and underlying commodity prices to come up with the LMP estimates.
Sure. And I understand if you could go back over to tab, well, actually, go to tab, or I'll just ask you a question. You can stay on there, Justin. Where you have the remaining net book value, or, I'm sorry, you have the replacement energy on that first table. Go back to the first table, I guess, really quick. That 224,514. That will correspond to the revenue on the market tab for that year. Is that correct?
That's correct.
Okay. Does the revenue, when Mitchell is operating, does its operation always coincide with Kentucky Power's load?
No, it does not. Mitchell is offered in economically, and it dispatches to a market signal. So as I discussed earlier, if it's offered, regardless of where Kentucky Power's load is, right? So it's offered in every hour. We have a must-offer requirement on the unit because it is the plant, because it's a capacity resource in PJM. If it's more economic to purchase energy, meaning that market energy is lower cost than Mitchell's variable cost to be dispatched up, then the unit doesn't dispatch up. The company's load
And I understand
settles
that.
at the
Yeah, I understand.
energy price.
Like you would make market purchases if the variable cost of operating Mitchell is cheaper, but
I think the opposite's true there. You'd make market purchases if they are cheaper than the variable cost of.
apologies, yeah, you'd make market purchases if the market price was cheaper than the variable cost of operating Mitchell.
Yes, sir.
But there might be times when the market price is higher than the variable cost of operating Mitchell, but Kentucky Power doesn't actually need the load from Mitchell in order to serve its customers. Is that correct?
That's correct. And so you're creating energy margins that are that scenario, and customers receive those back through the system sales clause in Kentucky.
And I get that. I guess in the alternative where you're looking at market purchases, the revenue when Mitchell is operating wouldn't necessarily represent the cost of purchasing energy to serve Kentucky Power's load. Is that accurate?
So just to be clear, there is no Mitchell in alternative 3. It is how would you replace the energy you would have received from Mitchell? And so alternative 1 includes that production costing and that hourly dispatch over that period of time. And it's saying Mitchell is going to run this much in these hours in these years, and it's all summed up in that table we just looked at. And so option 3 is saying, all right, well, I'm opting out of Mitchell under alternative 3, and instead I will replace that same energy and capacity with market purchases. So you don't have an option. So you would have received power from Mitchell during these hours and these amounts. You don't have that option now. So what is that cost to the customers?
And I get that. I guess the goal is to serve customers, or to serve Kentucky Power's load at the lowest cost possible.
Mm-hmm.
If Kentucky Power's load is occurring, when market prices are cheaper, but Mitchell is still operating when market prices are higher, but maybe Kentucky Power doesn't need that load, then the revenue from Mitchell wouldn't necessarily represent the cost to serve Kentucky Power's load. Would you agree or disagree?
I disagree with you. What the customers are facing in that scenario you just gave is an opportunity cost. They would have received those margins, but since you don't have Mitchell, they won't receive those margins. So it's an economic cost either way.
Would you agree, under alternative 3, it doesn't include, it includes, what you've done is estimate, the cost of replacing Mitchell's load, but it doesn't necessarily include the cost of market purchases to serve load when Mitchell's not operating. Is that correct?
You state your question again?
Yeah.
Please.
You looked at the revenue that Mitchell would generate to substitute for the cost of purchasing replacement energy from the market. But like we said earlier, Mitchell is not operating at all times necessary to serve Kentucky Power's load. And so this analysis doesn't reflect the cost of market purchases to serve load when Mitchell isn't operating.
So the companies, what these analyses show, what the company's asking for approval of in this case is, what do we do with this increment, this amount of capacity and energy that is currently served by the Mitchell plant in our portfolio? So we're not looking at all of the company's load or capacity requirements. This analysis is strictly like, what is the best option for customers around the Mitchell plant? And so, as we show in this figure, in alternative one is the lowest reasonable cost, continuing to take our interest from the Mitchell plant. And so that's when you look at the alternative 2 and alternative 3, we're not solving for the company's entire energy and capacity requirements. You're correct. It is comparing that apples to apples to what it would get from the Mitchell plant.
Okay. I'm looking at, could you go to tab PPA?
Is this the?
There's some that's
All right.
redacted, and I'm going to try to stay away from the redacted. If I ask a question that would require you to like get into confidential information, you can tell me, and
I think we can avoid it.
yeah. I really just kind of want to get into like what these numbers are. I don't know, the amounts there that are blacked out, like next to 450 and next to 500.
Yes.
Is it confidential to characterize what those amounts are?
No, just the amounts that were bid.
Okay.
The prices are what's confidential, and the resources.
That's what I thought. So those are capacity costs that are redacted from the public filing. Is that correct?
That is correct.
Okay.
So
And you can see there's a per kilowatt or dollar kilowatt per month, and then you've turned that into kind of an annual number there.
Yes, sir.
And I might ask this as a post-hearing, so we don't have to go in-depth into the confidential file and things like that, but I know you all had produced like kind of some of the RFP responses, and some of the other redacted information kind of reflects what units these are representing, I think, from the RFP responses.
They do, yes.
And that per kilowatt month price, would you be able to tie that to the specific document in the RFP responses that reflects that price? And I believe some of them, well, I don't want to go into anything confidential, but maybe tie it and kind of explain, how it ties to the number that's in the RFP response.
So maybe I can explain to you what it represents and how it functions in this. And that'll help.
Yeah,
So
go ahead.
these are both options. As I discussed in my testimony, we looked at, there's an economic ranking that was already done for evaluating the RFP, right? And we didn't look at anything that was less economic than Bright Mountain, as we already filed for approval of Bright Mountain, that renewable energy purchase agreement. It was denied, so didn't think it was prudent to consider options that were higher cost than what had already been denied. So we looked at the options that were still available to us, above, that were more economic, less cost than Bright Mountain. And so those were two different combined cycle plants, and the blacked out information, so that capacity cost is essentially like a demand payment, or some people might call it a toll, but it's how much in fixed cost do you have to pay the owner each month to receive energy at cost. And so that is expressed in $1 per kW month bid price. So you pay that every month, regardless of economics of the energy, but then you are entitled to the energy if it is economic. And so sorry.
No, go ahead.
Just gonna say, and then so you have the other side of that is the energy margins there. So it's assuming the analyses that evaluated the RFP, same type of dispatch analysis. They only run the plant only runs when it's economic, and then in the energy margins line, so we included here's the net energy margin. So the difference between production cost, market revenues. So that in 2029, the top one there, the 41.9 million, that is the reduction you would count against the fixed monthly payment you made for your right to that energy.
And I did have some question about the margins, and I'll ask that in just a second, but the capacity cost, really just what I wanted is like, I don't want to get into details of what's in the RFPs and anything, but kind of tying it to the number in the RFP, and to the extent there's any changes, explaining that, well, that was an updated bid or something of that nature. I don't even know if that's the case in these ones, but.
I took it straight from the bids that were provided to me from my commercial team.
Okay. Well, perhaps I'll ask if you can, as opposed to hearing, just tie it to the specific, because there was a significant amount of documents in there, so it's kind of hard to tie it out.
There are a lot of documents in an RFP request.
And then you mentioned earlier about, expecting the PPA prices to increase. Could you kind of just go into a little bit of detail about why you think that would be? Kind of all the reasons. I know you gave one, there's the capacity prices have increased. I don't know about energy prices, since they came in. And then any other reasons that you think would cause the PPAs to increase from what they were in 2023 or 2024 when they were, if they were updated at that time.
So again, I'll go back to our earlier discussion that it is a function of supply and demand. And as we sit here today, there is a great deal of public trade press, national news over increases in demand in multiple RTOs, especially in the PJM RTO. AEP has publicly stated the levels of load increases it has seen as recently as a few weeks ago in our Q3 earnings call. There's a lot of public press on increases in electricity demand in our states, across the nation, in the RTO. And so you have demand coming online faster than you can match it with supply. And so Econ 101, the price of the underlying thing you're solving for with the supply and demand is going to be higher. And so your incumbent generators, they're seeing the same news we are, and the price for their product is going up, right? They do not have to bid it to us. They can continue to sell it into a market. They know they're going to get no less than $329 a megawatt day in these next couple capped RPM auctions. But for that, it might have gone to the tariff cap that was $690 a megawatt day. Who knows where that's going to go? So again, it's basic supply and demand, and also confusing or clouding the supply side are those environmental regulations, right? Because new gas plants, and I think we discussed this in one or more discovery requests, that new gas plants are in theory capped at a 40%, a new combined cycle plant's capped at a 40% annual capacity factor, right? So if the market economics might dictate that plant would run at 80% capacity factor, but the environmental regime would limit it to 40. So in theory, you have to build two of the same plant to get to where you were previously. So there are a lot of converging supply and demand changes here. It's pressure from both sides. So it is. We've seen it in. We saw it happen in real time in this RFP as we got initial bids in, rebids as we discussed earlier after the environmental regulations. So.
How how have energy prices changed since 2023
How so? Like in what?
within PJM?
I mean, I don't have exact figures, but you can go out, the market monitor in PJM provides quarterly reports. I mean, I think this last summer, in general, energy prices were higher year over year. Just a function of higher average demands in the market. So if everything else was even, not certain it was, but let's say you had relatively the same gas price year over year, but you just had more demand, so you went farther up the supply stack. You know, that's how the RTO functions, is that the marginal cost to produce the marginal megawatt hour of generation is what all generators receive, and that's the hourly system energy price.
I'll probably do a post-hearing request to kind of request that kind of year-over-year change in energy price over the last couple of years.
It is publicly available on PJM's website as well.
Sure. Just to kind of get it in the record and make sure that we're looking at the correct thing. Similar with the capacity prices. And I can do this as a post-hearing request so as not to go into confidential information, but I know there were kind of 2 thermal units that were being looked at, and I don't know whether or not, I know you requested updates in 2024. I don't know if those, got an update, but would you be able to kind of give a response that looks at the change in the demand or capacity cost, that per kilowatt per month, and compares it, from the 2023 to 2024, to the extent there was a change, and compares it to what the base residual auction capacity price was in 2023 and 2024, or whatever would be the closest, corollary price. I guess would that be a possibility?
I'm not sure what you're asking, but maybe if you put it on paper, we could think about it. But
more so just like what were the base residual auction prices, that you would correlate most closely to the timing of the initial bids, and how did the change in the initial bid, if at all, correspond to the base residual auction price in the next year?
So again, the update in the bid prices was from the environmental regs being proposed, being promulgated after bids were received. So hey, these are now a new law. We don't want someone arguing change in law against us. So please, thermal bidders that are impacted by this potentially, refresh your bids. That is what was done. It's what we received. During that same period of time, there was a BRA clear that went to the roughly $220 a megawatt day. And then since then, there's been the 26-27 auction that cleared the $329 market cap. So
And I'll put it in writing, but I understood it was because of the GHG rules. Obviously, those rules then potentially affect the base residual auction price. So I was just kind of asking, and if you want to explain why those aren't connected, feel free to do so. But I'll ask it as a post-hearing request.
Oh, okay. Thanks.
We asked as in staff's 4th request for information, we asked kind of how the energy margins were calculated. And it was staff's 4th request, item 2G, and the question was explain how energy margins in Excel line 8 and 14 of tabs PPA referring to this document, public attachment 1, were calculated and provide work papers for those amounts in Excel spreadsheet format with all formulas. If the work papers have been produced, identify the portion of those work papers in the record reflecting the calculation of those amounts. And the response was, these energy margins were calculated during the process of analyzing the company's 2023 all-source RFP to determine relative rankings among proposals. The margins were calculated by multiplying the expected generated energy for a given year by the forecasted energy price, less the power production costs. And I guess, my question on that is, multiplied by the expected generated energy in a given year, is that the expected generated energy from the resource that is part of the PPA? Or was it related to Mitchell in some way?
It was from each of those PPA resources, right? So as I described earlier, you're paying a fixed charge each month to receive a call on that energy produced from that plant at cost. And so the same type of production dispatch analysis was done in a model, Plexos model, I believe. It then said, well, based on these costs that we've been given in the RFP, right, that was part of the RFP bid, provide us your variable cost estimates and all of your heat rate, all of your operating characteristics of the thermal resource you're bidding. And so how does that dispatch over this period of time? What market revenues does it produce? What variable cost does it produce? The net of those are the energy margins. So it is from each resource, not from Mitchell, right? Because if you're paying the fixed cost to have that call from that resource, you're going to take the economic energy whenever you can, again, to produce margins, buy down the cost of the resource.
I guess if that's the case, and I guess these aren't confidential, you have like the UCAP for the resources at issue here.
That's right.
I mean, these are substantially smaller than Mitchell. Would you agree? Or not substantially, but they are smaller than Mitchell from a UCAP perspective. Is that correct?
The amount of the plant's bid, yes. I can't remember if the plant itself was.
Yeah.
Plants in question were larger, smaller, same size as Mitchell, but there were segments of plants bid.
But when you're getting the energy, you're getting the energy that's associated with that capacity, right? Or
yes, sir.
Okay. So, to compare it to Mitchell, do you know if Mitchell would generate more or less energy in each year?
So as I stated earlier, these two resources in question in the PPAs, the highest economic ranked thermal bids were both combined cycle units. And so in a low gas environment, generally speaking, a combined cycle unit has a pretty low heat rate. It will dispatch, if you're not constraining it, it will dispatch more than a coal unit. And that's what we've seen. And again, if we go back to that same State of the Market report we've discussed earlier and discussed with the Sierra Club's attorney, it'll show you within that report, you can generally see that by different fuel types, different configurations, there's class averages of expected capacity factors. So yes, these two resources specifically generated at higher capacity factors. I don't think you can see in here offhand in this summary what the total MWH produced were.
And I understand it might be a higher capacity factor, but if it's a smaller unit, even if it's a higher capacity factor, you might be talking about different amounts of energy and/or energy that matches up better or worse than Mitchell does to Kentucky Power's load. Is that correct?
I mean, if there was some economic advantage, it would have showed itself in the analysis. So they're all dispatching under the same regime. You're offering them into the market economically, and you're letting the market dispatch them economically. So they're running when it's economic to do so and providing value to customers. And the bottom line is these units, unconstrained, did not produce a lower cost to customers than did the continue on with Mitchell, our alternative ones, the lowest reasonable cost scenario out of the analysis.
And to be honest, I'm not even saying that they would have been lower. I'm saying, I know your analysis indicates they're higher. I'm not, going to take a position one over the other, but my question really is, in part, in order to tie more closely to Mitchell, would you need a bigger unit, and then would there be more costs associated with this option?
you could also just add the two together. I mean, we were looking at, we looked at, we made everything apples to apples from a capacity standpoint with both of them. So I think whether you combine them, we averaged them, you get to the same place. When you make it equal to Mitchell, it's higher cost. And that's a function of the fixed payments that are blacked out confidentially. They're very high fixed payments you have to make to get the entitlement to the energy.
Back to the, where we had requested the work papers, are there work papers associated with that, or are these costs physically calculated in the RFP responses?
Say that again.
Because we kind of asked for work
costs?
papers showing the calculation of those margins, and you referred and said that it was part of the analysis of the RFPs. Are there actual work papers showing the calculation of those margins, or were these margins provided in the RFP responses by the respondents?
No, the respondents provided inputs. So heat rate, basically all of your operational characteristics of the plant in question. There are similar, right, the analysis was done, it's hourly production cost modeling. There are summary spreadsheets. I cannot produce a work paper of the hourly production cost. You'd have to come look in Plexos somewhere. But no, there are similar summary sheets to these, right? The company evaluated the economics. They're not taking the bidder's word for it.
If you go to the market tab, would there be, with respect to those margins, is there something equivalent to this work paper that shows the generation from Mitchell, the revenue from Mitchell, and then the variable cost from Mitchell?
Yes.
Okay. Would you be able to produce that for those two options as opposed to during data requests?
Yes.
Okay. Offhand, do you know the annual amount that each one of those PPAs was generating on a, I guess, gigawatt hour basis?
No, I do not.
I just didn't know if you knew how closely it corresponded to Mitchell.
Not offhand.
Sorry, I think I've asked these off, scratching some of these out. You can tell me if this is confidential. We mentioned kind of the two options that were, if you could go back to tab PPA, I guess. There were kind of two PPA responses that you used to calculate these amounts and then get the average. Are the two PPAs that you use there, are they still available? Like if you wanted to obtain the capacity and energy from those units related to those PPAs in 2029, could you even do so at this point?
I don't know.
Okay.
I mean, they certainly wouldn't be available at that price. You'd have to go through a new RFP, solicit new bids.
Okay. And the RFPs, how long, when they make the offer, how long are the offers open for typically?
There's a timeline in each RFP, and they're all a little unique. So I don't want to generalize. Each procurement's a little different. So it will state in those RFPs, bids are due by this date. Company will evaluate and notice shortlisted bidders by this date. The company will then negotiate. Then they will produce, they will shoot to have a regulatory filing by this date, so that prospective bidders understand the timeline and what, how because when they participate, they're essentially taking their plant off the market, right? So if they're bidding to you and they're negotiating with you in your regulatory filing, it's in theory costing them something.
So all those dates have passed. So to the extent you wanted to try to get these units, you'd kind of do a new RFP. So really, these are just used as example pricing. Is that correct?
They are indicative actual bids into a thermal Thermal RFP, yes.
Subject to all your testimony about potential changes since 2023 and 24.
That's right. They're conservatively low estimates. Yeah.
I don't want to get into the terms of these particular offers either, but is it typical for these thermal PPAs for it to be possible to obtain them for just 3 years? This chart shows 3 years. Is that typical, or would you typically need to do them for longer? And if you did them for, I know this is like a three-part question, but if you did them for a shorter amount of time, how would that affect the price?
So I just can't answer you. I don't know if anyone would contract for 3 years. I know the bids in this RFP were for longer periods than 3 years, and we used the pricing because we had it available to us. So I can't tell you right now in today's market if someone would contract with you for less or more based on a 3-year term versus a 10-year term or a 20-year term. I'd say generally speaking, especially if you're subject to potential future regulation on your emissions, the longer the term, the more risk you have if you're providing a fixed price demand charge, if you will, to an off-taker.
Sorry, I'm just trying not to repeat things here. I'm gonna pull up, can you pull up AG 1 attachment 2?
Is that this one?
Yes, that was that. And then if you could go to the OPCO rev requirement. I'm looking at line, if you can see that, this is Kentucky Power's response to AG 1.1 attachment 2. Are you familiar with this spreadsheet?
Yes, this is my regulated cost of service model.
Okay.
My team and I use this for many different evaluations of regulated generation assets.
Okay. So line 36, columns B through D.
Yes.
Says net revenue requirement.
Correct.
That reflects the annual cost of alternative 1 in 2029, 2030, and 2031 that are reflected in that table AEV1 of your direct testimony. Is that correct?
That is correct.
Okay. Does this include the ESM O&M or does this include the environmental surcharge O&M and the environmental surcharge rate base?
So it includes, as it shows on there on 33, it includes the catch-up payment explicitly from witness Khan's direct testimony. At a higher level, the answer to your question is yes, because it assumes, as I described in my direct testimony, that we roll the plant balance forward to 2028 and we get caught up. So it's a 50-50 allocation. And so the Wheeling Power, the environmental rate base is already in Wheeling Power's net book value. And so roll everything forward based on currently approved depreciation rates and the capital forecast, and then you take 50% of it. So yes, 50% of the environmental rate base be associated with getting caught up is included in this analysis.
I assumed it was. I was just trying to confirm that it was, because you've got base rates and you have the environmental surcharge mechanism, but to your knowledge, this includes the environmental surcharge rate base.
Yes, sir. And just to be really clear, that's a total net revenue requirement. So we know in Kentucky rate making here, that number will be broken into a number of mechanisms. We're just trying to summarize it here and show hey, this is the total cost of service from the plant.
Okay. And does it include the return on and the return of the 60.4 million catch-up amount for the non-ELG investments?
Yes, sir. So if you go back to the input tab,
Input tab. You can go to the input tab.
so when you look at that initial CapEx number there, the 617 million, right? So that includes the plant investment we're talking about. So it's all in there. And then if you go back to that OpCo Rev Rec tab, line 24 is the return on that rate base at the company's currently approved after-tax weighted average cost of capital. So you have all the plant included, and then you have the return on it, and then you have the depreciation expense on line 14.
For this spreadsheet, over what period is the ELG capital cost? I'm not talking about the catch-up amount, because I saw you had those reflected, going through 2031, but other than the catch-up amount, what period is it being depreciated over? Is it through 2040, along with the rest of the plant?
I believe everything in this analysis is through 2040. So the difference is on line 33, the amortization, the company's initial proposed amortization of the catch-up portion there to Wheeling Power was shorter than what we agreed to in the settlement.
Yeah. If Mitchell was taken out of service at the end of 2031, with the depreciation going through 2040, would there still be capital costs that Kentucky Power would have to recover from its customers associated with the ELG project?
So to clarify your question, you're asking if for some reason Mitchell stopped operating in 2031, just altogether?
Yes.
Okay. And you're asking then, under that scenario, would there be book value left to be recovered from customers?
On the ELG project.
I mean, unless it is amortized to some shorter period, yes, there would be net book value related to that the company
I thought that
recovered.
Yeah. I wasn't trying to trick you or anything. I was
I just want to
trying
make sure I
confirm.
was clearly answering your question. That's all.
Would the return on and the return of the amounts associated with the ELG project start to be reflected in rates for service beginning January 1st of 2026, based on this application where the environmental surcharge mechanism is effective January 1st of 2026?
Just to clarify, the return on and of the totality of the catch-up or just the environmental plant?
Both, I guess, but let's just stick with just the environmental plant, not the catch-up.
Yeah, right. So I got to point back to Witness Wolfram. He discussed this a little bit earlier, right? So you have two portions of that general $138 million of capital to get all the way caught up in Mitchell we've talked about. In this proceeding, included in company witness Khan's revenue requirement, and what we're asking for recovery of is the environmental portion of that. It's environmental compliance plan, environmental surcharge. So those costs would go in, if this was approved, whenever we noticed they would. I believe it's January, yes.
Yeah.
So you have that, but we are asking for prudency of the entire investment. And, I think company witness Wolfram has discussed how the company might propose to collect or get into rates the other portion, the non-environmental piece of the catch-up.
Going back to this spreadsheet, over what period that, now talking about that 60.4 million in non-ELG capital investment, is that also in this spreadsheet? It's included and it's being depreciated through 2040, is that correct?
Yes, sir.
Geez, I lost my place here. So that amount, my understanding is that amount would you're proposing that that amount would be, how it would be recovered would be determined in the current rate case, which has an approximate effective date of March 2026. Does that sound accurate to you?
I don't have a specific proposal on that. I believe it's whatever company witness Wolfram indicated earlier today.
If you assume that it is 20, let's just assume that it's the first quarter of 2026 when that, that would start being recovered.
Sure.
Could you go back to the, I'm sorry, the public attachment 1? Or actually, no, you can leave right there. I guess if we're looking at those three down there in line 36, year 1, 2, and 3, that's what was included in the alternative 1. If we wanted to compare alternative 1 against alternative 2 and 3, would you need to include the revenue requirement effects in 2026 through 2028, and then the net plant service that would remain after 2031 to kind of compare them on a apples to apples basis?
No, that's already been done in here. So whatever, right, whatever your operating expenses are, they are during those periods. The capital is inclusive of all those things, assuming that you do get approval to roll that into rate base, make that investment in 2026 or whenever this application is approved here in 2025. And then you roll the whole plant forward based on those depreciation rates currently in place and the other capital investments, the maintenance capital, things that Witness Snodgrass discussed earlier. And so you get to a end of 28 rate base because we're evaluating 29 through 31 in this application, right? And so you are going to have impacts, but it doesn't change the costs in 29, 30, and 31 here. Like all of those things have been accounted for.
Don't we typically want to look at the overall cost to ratepayers?
I certainly agree, but your costs in 26, 27, and 28 don't have an impact on what you do in years 29 through 31. Like, we're trying to make a decision here on what's most economic for customers. And you're right, you might have to spend some money to get there, but if you don't spend that money now, this option isn't available to you. So
I guess let me just hypothetical, and I know there's tons of variables. You can look at lots of different things, but if let's say the analysis from 2029 to 2031 came out, and there was alternative 4, and it was $20 million more expensive in those 3 years. But alternative 4, you wouldn't incur any revenue requirement effect from 2026 to 2028. If there was $40 million in revenue requirement effect from 2026 through 2028 in alternative 1, could you say that alternative 1 is cheaper even though you're incurring those costs from 2026 to 2028?
I'm not sure I can answer your hypothetical. There's not enough information in it. I don't know what option 4 is. Like, I don't have an option 4.
I guess I'm a little confused, and well, let me ask this question. Like, in your direct testimony table AEV2, you looked at the net present value revenue requirement effects of various alternatives. Is that accurate?
And Mr. Bellamy, if we get into the actual numbers, we need to.
Oh yeah, I wasn't gonna talk about the numbers.
We looked at the levelized cost of energy, the present value revenue requirement, average annual revenue requirements, and the upfront capital costs.
Okay. What's the purpose of, I guess, looking at the net present value revenue requirement there?
Mostly because people like seeing them. I personally think the important one is the average revenue requirement, because that is what hits customer bills. When you look at NPVs or present values for long-lived assets, they can be heavily influenced by commodity curves that are 20 to 30 years out. And our customers, frankly, don't care about what happens 20 years from now. They're worried about their bills in the short term, what is going to happen to them. So I personally prefer the annual revenue requirement metric when I'm analyzing cost to customers.
I guess to that point, you know, if you're looking at the short term, you know, if alternative one in the short term, you know, would require an additional revenue requirement effect in 2026, 2027, and 2028, would that be important to consider when looking at the cost of the alternatives in the short term?
Mr. Belling, I just have a question. You talking about alternative E1?
No, I'm talking about back to short-term alternative one.
Gotcha.
Yeah, so I think I see what you're trying to ask here. And so, again, the company has, has noticed and has quantified those amounts, the cost to customers in 26, 27, or at least in 26. I think it's a representative amount. And company witness Con had those in her testimony. We didn't ask her any questions, but I don't have her numbers in front of me. But those, again, let's look at the alternatives in Table 1. There's not over $100 million of cost to customers in years 26, 27, and 28 under Alternative 1. It's a much smaller amount. It's nothing that changes the company's conclusion that continuing to receive its energy and capacity share from the Mitchell plant is the lowest reasonable cost alternative.
And I'm not necessarily saying, I understand that you could still justify it. I'm just trying to understand what cost should be looked at when justifying it. And you know, if one alternative would result in costs, you know, in the next 3 years, the other two wouldn't, and then one alternative would result in costs, you know, of essentially a sunk cost that at 2031 that hasn't been collected. One way to account for that and compare the three alternatives would be to do a net present value revenue requirement analysis on all three. Would that be correct?
I mean, that could be your opinion. I don't necessarily agree with you. I think what we've done here is the right way to evaluate this for customers for the time frame in question. And trying to put all these options on an apples-to-apples basis is what we did. We have included the costs for the environmental surcharge and the environmental compliance plan in this filing. So I guess we have to agree to disagree there. There's no material revenue requirement impacts that change the answer, I guess is my testimony.
Could you pull up? I did have a question about a couple confidential items.
On confidential record now?
Yeah.
Okay. Candace?
Could you just tell me, there was talk earlier, about the uneconomic dispatch of Mitchell. Did you consider, I guess, recent incidences in which Mitchell has operated on an uneconomic basis, meaning that the variable cost of production were higher than the market price when you were developing these margins?
So I guess first off, I'm going to push back on the premise of your question. I don't agree that there has been uneconomic dispatch at the Mitchell plant. That's been my testimony in the company's 2-year FAC review here. It's been our testimony in West Virginia, and I disagree that it's occurred. What has happened is that the plant has remained online, dispatched down to minimums, right? So plants run in a continuum of megawatts. It's not just like we discussed earlier, you can't just flip them on, flip them off. And so the plant will run at minimums and then be dispatched up economically during the day when prices are higher, right? So if you need the plant tomorrow, but you only need it, PJM needs the plant tomorrow from, let's say, 11 a.m. to 8 p.m., you can't, but it's going to run, the variable cost overnight is less than Mitchell variable cost. You can't turn it off, right? Once you turn the plant off or you ramp it off, it is down for 3 days, as I discussed with Mr. Snodgrass earlier, and it's you incur a very costly start. So when you take all these, and you have wear and tear on the equipment, this equipment becomes very hot, then you cool it down, expands, contracts, it causes more, the more you cycle the unit, the more maintenance you end up spending on the unit. And so when you are taking into account the economics of dispatching that unit, it is not just the hourly energy price versus the variable cost. Like that is it's a very narrow view, and it is not the full picture of cost to customers, right? I mean, some of these starts cost, you're upwards of $1 million to start the unit, right? And so if they're going to need it the next 4 afternoons, you're not just going to turn it off. Right? So that, with that in mind, do you have more questions on that?
Yeah, I guess but you would agree though, there's, you say it's kind of operate at minimums, but it's operating at a time when the variable cost of operation is higher than the market price for energy, correct?
In that hour, but again, I won't agree that that's uneconomic because there's other costs you have to factor in, such as the cost of the start, the cost of wear and tear on the unit,
and that's
all
why
of
I
those
was
things.
Trying to narrowly define it in that way.
Yeah.
Obviously, you could take the position there's a reason that we're doing it this way, and here's why. And I take it that's your position. But as far as these margins here that are reflected in this spreadsheet, does it reflect any instances in which the unit is operating at a time when the variable costs of operation are higher than the market price at that time?
Yeah, yes, sir. It's a full production cost run, so it's evaluating hourly LMPs, and those are shaped over time, and it's evaluating how the unit actually operates. Like the software recognizes that you can't turn on the 1600 megawatt coal plant on and off like a light switch. So it's doing the same type of analysis at a much higher, more summarized level than like an RTO or PJM dispatch is doing. And say, well, the price curve says I need to dispatch the unit the next 5 days in a row for 12 hours, but then I wouldn't have it on. But I can't have the plant available to meet load economically during those times if I turn it off, because it's going to sit for 3 days before I can restart it. So that's all occurring in the production dispatch analysis. So yes, it is running at a negative hourly variable margin overnight so that it can be there to, in this analysis, to capture the economic margins in those hours the next days.
Can you provide, when this is run, it's on an hourly basis, but I'm assuming you can get the output on a monthly basis, can you not?
Yes, I can get it monthly.
Okay. Could you provide, I'll do it as a post-hearing, but this These production cost results on a monthly basis.
That are specific to, just to make sure we have it, specific to our response to AG 11, Public Attachment 1?
Yes, yes.
I believe so.
And then, I guess, is it possible to look at the monthly actuals of how Mitchell has actually run historically on a monthly basis with respect to variable costs and revenue?
Yeah, I think we provide that in every 2-year FAC case. I sponsored it last year. I don't know, there's too many cases to keep track of, but yes, we've done that.
Okay. I'll ask that as a post-hearing also.
I can tell you we have not prepared it for this case, but it's a normal course in the company's 2-year FAC reviews.
Okay, okay. And I might look at that and maybe tie it and ask for you to produce, results that you've already done, as well as any other years that you think would be appropriate. Just a couple more questions. I'm almost finished, and thank you for your time. Before I get to this, the revenue requirement calculations for both the alternatives that had the 100% gas conversion, or I guess any gas conversion of Mitchell, and also the natural gas combined. Well, I'll ask for just Mitchell first. The conversion of Mitchell, whether 100 or to 40% gas, did those include the cost of gas pipelines to Mitchell?
So you're talking about the post-2031 analysis?
Yes, sir.
Yes, so just to be really clear in that analysis, it is the gas pipeline costs, so running the lateral to the plant, is not included in the initial capital, right? Because that's not Kentucky Power, Wheeling Power Company's capital, that would be the gas provider's capital. And then included in those analyses, there is an annual cost of firm gas transportation, which encompasses the cost recovery of the capital outlay by the gas provider.
Okay. And then as far as the 1,200 megawatt natural gas combined cycle, was it anticipated that would be located at, actually, I don't want to go into anything confidential, I don't know. I'll scratch that. I might act that as a post-hearing request. And
I guess I can tell you, maybe this helps, that yes, we also included a firm transport cost in that. So like, assuming it's somewhere in that area where the West Virginia coal plants are currently, and here's the an estimate of similar firm gas transport costs, assuming someone's gonna have to build a pipeline to the new asset to cover those costs.
okay, thank you. For the full tower pair option and the shortened tower pair option, would I'm sorry to change gears on you, but I'm talking about the cooling tower, the supplemental testimony.
Yes, sir.
For the full tower pair option and the shortened tower pair option, would the tower would remain in service while you're doing the repairs? The tower and the plant generally would remain in service.
So you're saying, by full tower, you mean option 1 in table AEV SD1?
Yes, sir.
Yes, so that option assumes that the plant and cooling tower remain in service while that project happens.
Okay.
And by shortened tower, I assume you're referring to option 4?
Hey, before you get too far, we need to make sure that if we're going to talk about the outage length, that needs to be in confidential session.
Okay, okay.
Do we need confidential session then?
I wasn't intending on asking about that.
Okay.
I think I can answer this question publicly.
Yeah.
Option 4, no, you could not have the unit in service while you did that.
Okay. And with the new mechanical draft tower option, what would happen to the existing tower if that option was pursued?
Yeah, again, I think I can discuss this publicly. So what would happen is that you would cut down, shorten the tower to a safe height where it could remain on site until there was an opportunity in the future for it to be fully removed or decommissioned.
Can you talk about whether or not there's a potential D-rate to Unit 2 in the shortened tower scenario and the extent of that?
Again, that's confidential.
Okay.
We can talk about it, we just have to go into
Yeah,
confidential session.
I think I talked about that a little bit earlier in the first confidential session, but
I think if we need any additional information, we'll do a post-hearing, I think. That's all the questions that I have. Thank you all.
Okay.
thank you.
Commissioner Wood?
I just wanted to ask a question about we've had a lot of references to confidential information today, and I'm gonna play my new commissioner chip and ask why a lot of this information is confidential, given the fact that Kentucky Power has a monopoly serving electricity in this market.
Yeah, great question, sir. So what we're trying to do is protect, so these are all potential future things we might engage in, right? And the worst thing you can do, so when we do projects like this, we do requests for proposals and we competitively bid them. And so you don't want to tell the world what you're estimating the project to cost before you competitively bid it, because if you do that, I imagine the lowest cost you're going to get is your publicly announced assumed cost of that, right? So we're hoping that by not providing those costs publicly, that you could drive savings for customers, and be competitive in those procurements.
Okay, very well, and I'm not looking at all those numbers, so I can't get real specific about each individual category, but just almost from an outsider's point of view, I wondered why, there wasn't more transparency, but.
In some of them also, so like when we were discussing the PPA bids earlier, so like we have to sign non-disclosure agreements with the parties so that they will disclose to us what they're willing to transact at. And so we have to continue to honor those so that they will continue to provide us options in the future, right? And they have clauses in them that we can show the regulatory bodies that we need to receive approval of them, right? They're in line with that. They just don't want us showing what they're willing to transact at publicly, because again, it would harm them, as well as our customers. If everybody knows, here's what we're evaluating, if there's potential to get something lower.
Okay, gotcha. Can you tell me what the load is for Kentucky Power's territory, or how much electricity has to be produced every year to serve that territory?
I think it's roughly 5 million megawatt hours annually. I think our sales are in that range, 5 to 6 million megawatt hours rates. And then you have average demand versus peak demand. I think our average demand is somewhere in that 600 megawatt hours an hour range, right? And then you have peak demand over 1,000 megawatts. I think Mr. Wolfram, in his direct testimony, has a chart that shows like our peak demands.
And that demand cannot be met without Mitchell? Is that your testimony or what the company is saying today?
It can be met. It will. Well, our testimony today is that without Mitchell, it would be more expensive to meet the energy and demand requirements of our customers. So that's why we're proposing Mitchell as the lowest reasonable cost option.
Because you would have to buy off the market.
We would have to find something else, right? And in very short order. So we would essentially be going to the market.
Or something else, yeah.
We would go, whether it's the market or it's the market for PPAs, we would go to the world and say, hey, we have a very big need in a very short term here. And again, it's still out 3 years, but it's short term from a planning perspective and what we have to provide to the RTO to show them that we are going to comply with the approved tariff, the federally approved tariff, to meet our reliability requirements.
And so I guess, is there more than one reason that you have to keep Mitchell going? And is the other reason due to requirements that PJM has? Is that what I heard you say earlier, is that you have to get so much capacity in the bank, I guess, so to speak, in case they demand some more resources to meet a customer's need maybe somewhere else?
So it's not necessarily for someone else's customers, but each, I guess what we in PJM you generically call Kentucky Power a load-serving entity, right? So they participate in the market as a load-serving entity and as a generation owner and a resource owner. And so as a load-serving entity, if you're serving load, you have to meet that load's peak requirements plus a reserve margin. And so like you don't plan to zero. So like right now we're moving from about 15% reserve margin to about 18%. So reserve margin's going up because the RTO is worried about having enough supply overall to meet demand. So there's that. And then can you ask your question about continued operation of Mitchell again? I didn't quite get all that.
Neither did I, probably. I'm still trying to get used to the whole RTO thing, and some utilities participate in it, and some utilities like KU, LG&E don't. And I'm wondering if working in the RTO environment is good for the ratepayers of Eastern Kentucky. Does this add to their cost of electricity? Or would it be lower if you all did not participate in
So for the company here, so for Kentucky Power,
right.
AEP used to be its own control area going back prior to entering into PJM in 2004, I believe, which, you know, we used to do the same thing as LG&E KU. Right now, as you stand here today, my high-level belief would be that it would be more expensive for our customers to be served in that same fashion as LG&E KU. Like we don't have the same breadth of resources. Like they're a larger company. So even when AEP was its own control area, Kentucky Power was part of a federally approved pooling agreement. So all of the AEP companies in our Eastern Interconnection participated in that control area collectively so that they could share risks and cost efficiencies. So I think the smaller you get from a utility, the harder it is to operate it, you know, as an hourly reliability area.
Okay, and did you say that KU, LG&E is a bigger company than AEP, or bigger than Kentucky Power? Or?
They're much larger than Kentucky Power. I don't know the stats offhand, but I don't think they're larger than, from a customers and generation and transmission perspective, than AEP.
Very well, thank you.
Commissioner Reagan?
Two questions for you. Just to go back to the discussion that you were having with Mr. Shope regarding the reporting structure, I think from AEP to Kentucky Power and to and how that works. So you model for all the different subsidiaries?
Yeah, so my team provides services to all of our operating companies in 11 states. We cover a great deal of rate cases, both general rate cases. So part of my team is involved in the general rate case that's going on right now, working with Mr. Wolfram. We work on new generation CPCNs across the company's 11-state footprint. Well, not all of them are vertically integrated, but the vertically integrated states we do. We also work on fuel and energy supply cost recovery for all of our states. So yeah, my team covers a lot of ground for all the OPCOs.
And when you do the analysis and you give your opinion, you're saying the subsidiary presidents, are they independent? They do what's best for the company that they're the president of?
Yeah.
They're not directed by AEP?
Yes, ma'am.
They have to do this, or do they act independently?
Yes, ma'am. So like in this case, in all these cases, they're providing us, here's the decision we've made, and now I need you as a shared service employee and your team, your subject matter experts, to produce this part of my case. And so, you know, Kentucky Power told my team they needed to do these analyses, so we did them. They told my team that we're going to file a base rate case, so we produced those schedules. You know, that's how it flows.
Okay. And do you code your time then to the different subsidiaries? Okay.
I sure do. It takes a long
You have
time.
Okay.
Yeah. I have to do it Friday.
It's
an
not
off
fun.
week. Yeah, no.
And then just one last question, that if the commission were to disallow any of the specific cost components of the settlement agreement, how would that affect your recommendations?
If you disallow any cost components in the, can you give me a specific example?
Let's say that we did not, let me just look at this. A repair option or something like that. Any cost components that would cause some of your recommendations to change?
I don't know. I think just in general, I'd point you back to like my table AEV1, and even with everything we've discussed in here throughout the litigation, it is still by far the lowest cost option for our customers. So yeah, I think that's, as I sit here today, that's going to be my recommendation.
Okay, thank you.
Thanks.
Yeah, sorry.
On direct, your counsel asked you some questions, and you talked about Mitchell, the Mitchell operating agreement,
Yes, ma'am.
and how if one of the parties to the operating agreement, so either Wheeling or Kentucky Power, needed to do an uneconomical dispatch, then that would not be billed to the other party. And it's not something the PSC would have to rule on. It would be an intra-company decision. So I planned to ask you, should I assume that that's happened? But is your position that it hasn't because there's not been an economic dispatch?
There's been no, my position is there's been no economic dispatch, and the companies, Wheeling Company, Wheeling Power Company has not been told by the West Virginia PSC to, or ordered by the PSC to dispatch the Mitchell plant to some predetermined level of capacity. So the company, you know, as Mr. Snodgrass discussed earlier, like we have a production operations team, we have a commercial operations team. They have operated that plant on an economic basis for Wheeling Power and Kentucky Power just as they would. So, and I also don't think there's been any different allocation of the costs or the energy revenues from the Mitchell plant other than 50-50 through the operating agreement. It's been the capital that has been disproportionately allocated because after the 2021 ruling where commissioned the company's application to participate in the ELG project was denied, right, there was a recognition that there was some capital that was going to be used by the, you know, there was had a useful life of greater than 2028. So that's how you started getting into that disproportionate allocation of capital costs under the agreement. But it's just happened for capital, to my understanding. There's been no energy, no revenues, no allocation made that other than 50-50.
I was just asking questions earlier about times when there was too much coal on the ground. And so Mitchell needed to burn the coal because they had to accept delivery of other coal, and I know there are storage restrictions, and so they had to go ahead and burn, even though it was not the best decision based on market price at the time. That's what I was referring to earlier when I was asking about uneconomic dispatch. That happens, right?
So as I sit here today, I do not know if the company's had to reduce its bids to undergo decrement pricing, as we would typically that's how we would typically characterize it, to control the physical level of coal on the ground. All of those things generally get brought up and disclosed in our 2-year FAC reviews. The last one I participated in, right, the opposite was true. We were trying to get as much coal as we could. It was for that 21, 22 period when commodity prices were very high. I don't know the answer to your question post
Okay.
2022 right now, but again, just generally speaking, I'll say that we always act from what's economically best for our customers' perspective, right? So if we have contracts for coal deliveries based on our forecasts of how much we think that plant's going to operate, we tend to abide by our contracts. And so then we look at what are the options available to us? Is it keep the unit online more? Is it can we pay a liquidated damage? Can we do offsite storage? Like, look at everything available to us and make the least cost decision for customers there. And
I feel like that has been acknowledged in the case record already, but if I need it cleared up any further, we'll send a post-hearing down. And that's all the questions I have. Is there a redirect?
I have two very quick redirects. One, earlier in Mr. Bellamy's questioning of you regarding the 2023 rebid in 2024, you said that was because the greenhouse gas rule was proposed. Isn't it true that was because the greenhouse rule was finalized in May 9th?
yes,
24?
wrong P word. I think promulgated was the right word.
Yeah, I wanted to
Yes.
make sure that we weren't confusing that rule action by the EPA with the rule actions that are kind of up in the air now. The other question, there was a lot of discussion from questions from Mr. Schoaf about the alternative to convert the power plant to 100% gas, and the cost of that, and then we had some discussion from Mr. Bellamy about the various alternatives, E1 through E5, and the various trade-offs and benefits of each of those. Those are all at a future decision point, correct?
Correct. That's not what we're here to talk about today.
But the company can't get to that future decision point without staying in Mitchell, is that correct?
That's correct. The company needs to get caught up to have its interest in Mitchell through 2028 to get to that, post-2028 to get to that decision point, right?
Your Honor, those are the only questions I had.
Okay, any recross?
No, ma'am.
All right. Any reason this witness can't be excused? All right, Mr. Vaughn, you're free to go.
Thank you.
And is anyone, that was your final witness?
Yes.
Yes, Your Honor.
Will we be recalling, does anyone have a reason to recall Mr. Wolfram? Is that your case then?
Yes, Your Honor.
Yes, Your Honor.
I don't know which one of you is lead counsel. I'm
sorry.
sorry.
It's
It's
all
Glass.
I thought you were looking at that. I spoke last time. My apologies.
I apologize. All right, and so at this point, we've had a request for a quick break, and then we'll come back and do the interveners' witnesses.
Thank you.
Thank you.
10 minutes.
Thank you.
All right, back on the record, case number 2025-00175. And let's see, Attorney General in KIUC, would you like to call your witness?
Yeah, Lane Collin is here virtually.
All right. Hi, Mr. Collin.
Hello, good afternoon.
All right, I can hear you fine. Can you hear us okay?
Yes,
Oh, good. I
the
hope.
sound is much better.
Oh, good, thanks. Jim is a miracle worker. We're lucky to have Jim Rhodes. All right, counsel?
Mr.
Well-
Collin, can you state your name and job title for the
I
record?
better swear him.
Oh, yeah, that'd be great.
Amateur move. Mr. Collin, would you raise your right hand to be sworn? I bet you're raising your right hand, but I can't see it.
Oh, I am, yes, yes.
Can you put it in the view?
Swears he.
Maybe put it in the view? Put your hand in the view?
I see it. I see it. Well,
Oh, there you go, now you can see it.
okay, okay.
Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes.
All right, thank you, counsel.
Mr. Collin, can you state your name, job title, and employer for the record?
Yes, my name is Lane Collin. I'm the president and a principal of J. Kennedy and Associates Incorporated.
Okay, and what was your role in this matter?
I was asked by the Attorney General and KIUC to review the company's requests, and there were multiple requests, and address our agreement with the issuance of a CPCN for the additional cost to recover, or to pay for, I should say, the ELG investments to continue the participation in the capacity and energy output of Mitchell after 2028, to address the accounting issues and to address the tariff issues.
Did you file direct testimony in this case?
I did.
Did you sponsor responses to data requests from the staff and the company?
Yes.
And do you have any corrections to that testimony or those responses?
No.
If you were asked those same questions today, would your answers be the same?
Yes.
Okay, the witness is available.
Okay. Applicant, any
We
questions?
have no questions.
Okay, and Mr. Kurtz, this was your witness too, right?
Yes.
Sierra Club.
No questions, Your Honor.
All right, staff.
I just had a couple quick questions maybe. Mr. Collin, in your testimony, I think you had testified that you felt like, paying the cost in order to retain Mitchell was the least cost option, I believe, at least in the short term, and that it kept options open. Could you just kind of explain your line of thinking on that in a little more detail?
Yes, I agreed with the company's case that continuing to invest in Mitchell and to pay Wheeling Power for the ELG costs, or Kentucky Power's share of those costs, was the least cost option and provided the most flexibility after 2031 in terms of either continuing to operate that facility or modify it so that it could continue to operate.
As far as, the operation in the short term or being the least cost option, what was your, thinking on that?
Well, I reviewed the company's economic analyses, more specifically the table in Mr. Vaughn's direct testimony, and it was clearly the least cost option for the 3 years, 2029 through 2031.
Okay. I don't have any other questions. Thank you.
Okay, Commissioner Wood,
I don't have any questions.
Commissioner Regan?
I do not have any
Okay.
questions.
Nor do I. Any redirect?
No.
All right, any reason that Mr. Cullen couldn't be excused? All right, thank you, sir. Nice to see you.
Oh, well, it's good to see you all too. Thank you.
All right, and do you have any further witnesses, Mr.
No, we do
Jones?
not.
All right. Sierra Club, would you like to call your witness?
Yes, Your Honor, we called Miss Debbie Glick.
Please.
Yes.
And while he's finding that, I'll go ahead and ask you to approach the witness stand, and I'll swear you in. Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do. Thanks.
And if you have what you need, be seated and tell us your full name and business address.
Yes, my name is Devi Glick. I'm a senior principal at Synapse Energy Economics, business address 485 Massachusetts Ave in Cambridge, Massachusetts.
All right, thank you, Council.
Good afternoon, Ms. Glick. Would you please, just once again for the record, state your name, title, and employer?
Yes, Devi Glick at Synapse Energy Economics, senior principal.
And in this case, did you cause direct testimony to be filed in this proceeding?
Yes.
Do you have any corrections or changes to that testimony today?
No.
And there were no requests for information directed to you in this proceeding, is that correct?
There were not.
Your Honor, the witness is available for cross-examination.
And for the applicant,
But no questions.
for Attorney General's Office, KIUC,
No questions, Your Honor.
staff.
We did have just a few questions. I know one of your opinions was that the least cost option, at least for the long term, was the conversion of Mitchell to lower cost, or to the conversion of Mitchell to 100% gas. If that were the least cost long-term option, would that not also support the short-term investment into Mitchell now in order to retain that long-term option?
So I think what concerns me is that all of the analysis required to demonstrate that conversion to gas is the least cost option hasn't been done. So there's more than one way to do a natural gas, operate a plant on gas. You can do a simple conversion, you can repower, which is a more extensive construction activity. You could reuse the site. So there's been one type of analysis done on a gas plant conversion option, but it's not clear to me also that the other co-owner would necessarily agree. So if the company commits to continuing to own the plant and then Wheeling Power says no, now they're stuck. So I think what I'm concerned about is that by locking in, there's a lack of optionality, and there seems to be this 3-year period where we're being told the only option is to continue operating the plant, and you have to lock it in for the rest of its life in order to have it for the next 3 years. And that concerns me because I feel like there are other options that haven't been pursued for the near term, and it's concerning to lock it in for the long term.
As far as the timing of locking in the option of maintaining Mitchell, past 2028, are you familiar with, I guess, how far out load serving entities within PJM are required to obtain capacity?
So the capacity auctions generally happen like 3 years in advance. My understanding is AEP is a FRR, a fixed resource or reserve requirement entity, so they don't participate in the auction. So I mean, they still have to have the capacity they need several years in advance. But one of the recommendations I put forward was to have a separate agreement with Wheeling Power, at least a short-term agreement to maintain the capacity. In his rebuttal testimony, Vaughn did not indicate that he'd had a conversation with Wheeling. On the stand today, he said he has had a conversation with Wheeling, that's not possible. I'm still curious why the only option is to pay the full cost of service. Because if Power has all this capacity now, if they regain ownership, they now have a huge amount of excess capacity they can sell in the market. But the price that they should be able to offer that to Kentucky Power for shouldn't just have to be the full cost of service. Like, I haven't seen the analysis, I haven't seen any numbers that indicate that that's the only cost, that has to be the cost.
If they were offering it into the market, if Kentucky Power no longer had a share of the plant and Wheeling was offering that portion into the market, would you expect them to demand market rates for the capacity and energy that they were offering from that plant?
Yeah, so I would expect that the PPA price, the amount that Kentucky Power would have to pay, would have to be higher than what Wheeling Power could earn selling that into the market, which is not the same as the cost of service. And
I know you had some recommendations regarding the PPA option, but assuming that that you accepted the PPA options as being a reasonable, estimate of PPAs, would you assume that Wheeling offering its capacity into the market that it would be offered at a similar price to other PPAs?
Not necessarily. I think the part of it has to do with how much it costs to operate the plant. So I'm not sure if all of these plants are also in the same market where they're located, what other factors they're using to price the power they're selling to Kentucky Power.
With respect to the PPA option, I know you had recommended to upgrade the bids, and Mr. Vaughn's response in part was, that would likely indicate, or that the bids were conservative because they are old and energy prices and capacity prices are increasing. Would you agree that energy prices and capacity prices within PJM are increasing such that you would expect to see increases in PPA prices?
Yes, I would agree. That's likely.
So I guess along those lines, would you agree that the PPA pricing in Alternative 2 is likely lower than you would expect if they rebid the PPAs at this point?
I think, yes, for the short term. I think going back to what you were asking me before, what concerns me is that the alternative, when you look at the 3-year cost of the continuing ownership in Plant Mitchell, that's just the 3-year cost. So while there might be a higher short-term cost with the PPA, you're not locking in that long-term cost. And that's the difference. So I do agree that the PPA might be more expensive in the short term, but I think it's problematic to just look at a 3-year cost and make a decision about locking in a plant for over a decade based on just that.
Would you agree if you included all of the costs, like a net present value of all costs, including before 2029 and to the extent there's any net plant left in 2031, you did a net present value on all that, did a net present value on the PPA costs, and that showed just in that short period that the Mitchell option was cheaper, that would, whether or not you were going to keep operating Mitchell into the future or not, that would establish that incurring the proposed cost would actually be least cost currently.
But my understanding is that you have to lock in, you have to continue your ownership of Mitchell over the long term to have access to that option. So that's why I'm saying I'm concerned about just looking at the 3-year comparison, because one of them is 3 years and one of them is not.
So you're thinking that if they lock in Mitchell now, they can't ever get out of Mitchell beyond 2031. That's what you find to be problematic?
Yeah, as the information is currently presented, it's the option is you get back in for the lifetime of the plant versus not. I think it's great if there's another alternative or if there's information that the company can provide where there is flexibility to get back out, and that's something that they're considering.
I guess what's the basis for your understanding that they can't get out in 2031 if they don't want to? Or if they want to, I'm sorry, if they want to get out in 2031, what's your basis for the understanding that they wouldn't be able to do so?
So my understanding is they're asking for permission to extend their ownership share through 2040 or beyond. So I haven't looked at the contract terms to see what the exit parameters are. I'm just operating under the assumption that we're considering signing the contract to retake ownership or not. And if they're being asked to repay all of those costs, I think part of the concern is also that they're now, what does that mean if they were to exit in 2031? Are they still repaying all of those costs from the prior ELG and capital investments? And is that cost still being passed on? Because that's a pretty significant cost. That is, my understanding is that 3-year analysis does not take into account paying the entirety of that cost, even if you get out in 2031.
I didn't have any other questions. Thank you.
Okay, Commissioner Wood,
No questions.
Commissioner Reagan?
No, but that's an interesting thought you just had. I just have to think about it a little more. Thanks.
It's like you're not suggesting it would be cheaper just to buy from the market.
No.
And because they're sister companies, Wheeling and Kentucky Power, that doesn't mean they're obligated to offer each other a kinfolk deal on prices, right?
Doesn't mean they're obligated to, but they have, their parent company ultimately has a financial stake in an arrangement that is mutually beneficial, that makes everybody better off. And that arrangement could fall somewhere between the cost of service and what they earn in the market, is more my point.
But why wouldn't Wheeling just, if they're going to sell their excess capacity, not just sell it at market price? You're saying that their parent company should direct them, or could direct them, to give a better price to Kentucky Power?
Because I think my position is that the parent company could look at the situation and understand that there's uncertainty from the commission on whether or not they will be allowed to upgrade, pay for the cooling tower, on whether West Virginia will allow the plant to convert to gas. There are rules in West Virginia that the commission's put forward on requiring coal plants to operate at certain capacity factors. So I could see there being just uncertainty on whether there would be intervention and to not allow a coal plant to convert because there's a desire to keep the plant operating on coal for policy reasons. So I could see the parent company looking at that context. I can't speak for them at all, but.
And if it were a 3-year contract rather than a 12-year contract, you would find that more reasonable?
Right, because then there would be time for the commission to hear the CPCN for the steam tower conversion, to evaluate, look at the analysis on conversion to gas, to have the company do all the analysis, present the options, and make a decision on that. And I would have no problem with signing the extension if the plant is converted to gas, because the analysis showed that was the least cost option.
And the full cost of service is getting amortized under the settlement through 2040, but you're suggesting that they wouldn't have to do the full cost of service?
Right, for the 3-year
Just do
period.
it 3 years.
Right.
I don't know how realistic any of that is.
Yes, I don't know.
Okay. All right. That's all the questions I have. Anything further from commissioners?
No.
Yeah. For applicant, do you have redirect? Or, sorry, do you have redirect?
I do not have redirect, Your Honor. Thank you.
Okay. All right. Any reason this witness can't be excused? Ms. Cook, you're excused. Thank you. And I believe that brings us to the end of our witnesses. Anything else at this time? Any exhibits that need dealing with? I don't believe anybody moved to admit anything today. That wasn't admitted, so, okay. All right. As far as post-hearing data request, staff, could you issue summary of your request by November 21st? Ben, sorry, Mr. Bellamy.
I'm sorry. Sorry about that.
Issue data request by November 21st?
Yes, we can do that.
I'm sorry. Caught you just as soon as you were getting asked a question. And then if the requests are up by the 21st, keeping in mind that the final order would be due in this case December 30th, would December 5th be enough time, Ms. Glass?
Yes.
And
We would make a request to brief this case if
yeah,
you'd be so inclined.
I was going to suggest simultaneous initial brief December 9th. Unless there's
Okay.
strong objection. I know, we're right in the middle of holidays here.
No, that is consistent with what we were thinking, so that works, yes.
Okay, and if a response brief is desired by either side, simultaneous response briefs, December 15th. And that gives us a tight turnaround for December 30th, but we're
As long as that works for your schedule to get your order out by December 30th, that is completely fine with us.
I think we're even going to try to
Just gonna
shoot
call
for.
you for delivery for treats while we're here.
I think,
Response date,
I'm sorry?
the response date, what was that?
Oh, simultaneous response briefs by December 15th.
15, okay.
And we will endeavor to get that out before Christmas, but don't know how successful we'll be. Because all of our utilities will file all their rate cases all December. All righty, anything further before we adjourn?
Just one question, Your Honor, and this is mostly for the applicant, I think, but you all have a court reporter here today. Do you know when the transcript might be available?
Yeah.
We would like it sooner if you can do it. Can you do before Thanksgiving?
Yeah, we can get it whatever day you need.
We'll get it.
Thanksgiving's on the 27th, Thursday, so anytime before that.
Early that week.
Earlier that week, maybe Monday, Tuesday?
It's the Tuesday or the 24th of Monday?
The 24th would be great if you can do it. We'll take it the earlier the better. Does that work for you, Mr. Schoaf?
Yes, that's helpful. And will you all be filing it in the docket?
We will. We will file it into the record as soon as we can after we receive it. So we'll try and get it in on Monday, and if we can't, it'll be in on Tuesday.
Understood. Thank you.
Anything further? All right. In that case, we are adjourned.